audio's through here.
The thumbs up. Okay, the meeting will resume. Okay, the zoning board conducts a public hearing to take sworn or first testimony from all interested parties. Both supporters and objectors on each case appearing before the board tonight. This is the only opportunity you will have to present testimony in opposition or support of the petition. Only those interested parties that have submitted notice 24 hours prior to tonight's meeting are allowed to make statements and also cross-examine the petitioner. Okay. Others appearing here tonight and wishing to speak before this board must fill out a form located on the table in the back of the room and turn it in to Jackie or Melissa, and you are allowed to make statements only. You are not allowed to ask questions. Groups that oppose a petitioner's request are asked to appoint a spokesperson or spokespeople to speak for the group in order to avoid repetitious testimony and to save time. Repetitious and off-the-subject testimony may be ruled out of order. Please refrain from repeating and be as factual as possible. Following the public portion of tonight's hearing, or the next several nights' hearing, the zoning board will enter into deliberations where they make a finding of fact based upon a variety of different considerations. The board is not bound by strict rules of evidence, and it may exclude irrelevant, immaterial, incompetent, or repetitious testimony. But the zoning board does consider the following when deliberating on all cases. 1, the county zoning ordinance. 2, the county comprehensive plan. 3, the county land use plan. 4, local municipalities comprehensive plans, the public benefit, and the best interest of the county. For code amendments, the zoning board makes a recommendation to the county board. For code amendments, the land use committee will also review those cases and make a recommendation to the county board. The land use committee meets the second Tuesday of every month. And for code amendments, the county board has final authority on those cases. And the county board meets the last Wednesday of the month. Okay, introductions tonight. I'm Dwayne Leston, Chairman. Jackie is our Community Development Administrator. Matt is our Assistant State's Attorney. Melissa is our Administrative Assistant. Cindy is our reporter tonight. In the first row is the zoning board members. The second row is the land use members. And the third row are county board members. Does anybody have any questions before we start? Yes.
Mr. Chairman, I'd ask that everybody place their phones on either mute or vibrate so we don't have to listen to phones ringing and everything.
Okay, double check your phones. Okay. We will call the first case tonight. Case number 22-19-A. The petitioner is the United Citizens of Tazewell County, LLC. Agents and representatives are Attorney Phil Ludicons. I'm sorry if I pronounced that wrong. Eric Schmidtgall, Craig Kilby, Jeff Kaiser, Brad Long, and Amber Towell. Okay. The first case is Section 153.09, 6-month moratorium on the issuance of a special use permit for WECS. Okay, those representatives and agents for the petitioner, are you all going to talk on this case? No, just one? Okay, if you will go to this podium over here, please. Right here.
Well, I think Mr. Griffin and I both are going to speak here for a second. If it's acceptable to the ZBA, I don't see that the moratorium argument will take more than about 30 seconds. It's really kind of they're intertwined. So if at all possible, I think we both would agree just to do them at once to save you time and going through the procedural hassle. It's up to ZBA if you want to do it, but there's not a lot going to be said at one that's not at the other.
So you want to combine the two cases?
At least for record purposes, yes.
You want to present evidence at the same time for both cases?
Yes.
And so the information you are presenting is for both 2219A, which is the moratorium, and 22-20A, the new code. Is that correct?
That's correct.
Yes, you can present them, but we will deliberate on them separately.
Yes.
Okay? So at the same time, I'm going to call case number 22-20A. Petitioner is the United Citizens of Tazewell County, LLC. Attorney Philip Lukahans, Eric Schmidt-Gall, Craig Kilby, Jeff Kaiser, Brad Long, and Amber Towle. And it is a new code amendment for 153 wind energy wind farms. And so we will call both cases at this time, and it will be a 90 minutes for both cases. Not 90 minutes for each case, 90 minutes for both because you combined them.
Correct.
Okay?
Do they have a PowerPoint that they're going to present?
Brad, can I get one of those also? Thank you.
Chairman,
Did you get one?
no, just the chairman will need one.
Well, I'll need one for that, yeah.
Okay, do you have any more? Wouldn't it be advisable that the chairman would have one?
I think Wayne is going to offer.
Thank you.
Can I proceed? Mr. Chairman?
Okay, Name and address for the record.
Yeah, Philip Lutkehans, Lutkehans, 105 East Irving Park Road, Itasca, Illinois, 60143. Represent. I have no idea.
Doesn't have one.
Yeah, it doesn't have to be, but. Nope, there you go. Now it's gonna be left.
Thank you. Which is okay, because I had a 10 speak, so. It scared me.
Sorry.
If I speak too quick. Yeah, great, whatever. Okay, I represent the United Citizens for Tazewell
Do your
County.
name and address again for the record.
Okay, Philip Lutkehans, Lutkehans, 105 East Irving Park Road, Itasca, Illinois, 60143. I represent the United Citizens.
Okay, wait a minute. Do you hereby swear or affirm to tell the truth, the whole truth, and nothing but the true self you got me?
I do.
Okay,
I represent the United Citizens for Tazewell County, who have submitted both of these text amendments. For the record, the moratorium is just because these often take months and months to go through this process. The thought was the moratorium would allow you to go through your process to resolve issues with a wind ordinance, which is, I think everyone would clearly agree is not, is outdated, hasn't been updated for a long time, and is not very detailed compared to those of the rest of the state of Illinois, or at least the majority of the state of Illinois. If you're able to go through the process on a relatively quickly basis, there's no need for the moratorium, but what you do not want to have happen is you don't want to have wind developers submit an application under the current zoning ordinance, because it leaves you very little protection as a county. But speaking of that, let's be clear. My clients are not against wind energy. We just want reasonable, safe development of wind energy that does not affect the property values and the health, safety, and welfare of Tazewell County. As I said, the current ordinance is inadequate, not up to date with today's standards. None of this that we're proposing would ensure that wind projects are not built in this county. Wind companies may have to pay more and be more diligent, but nothing that can't be done given the profits. If you go to the text amendment, a lot of this will follow that, and then we'll talk about certain exhibits as we go. Section 153.03, it just allows the municipalities to have siting approval within 1.5 miles of the municipality. The municipality can object within 1.5 miles, and they have zoning authority up to 1.5 miles outside of the city limits, and we're asking that just be put into your ordinance so that everybody's aware of it. In 153.04, and I'm just hitting the highlights because otherwise there's no way we'd finish this in 90 minutes. You will see about halfway through the first page, the paragraph, all special use applications require approval of majority go to the county board. We think this is such a huge issue that this should be something that's decided at the legislative level, that special use applications are things that really should be looked at after a full record and have approval or non-approval of the county board, the elected officials of Tazewell County. Underneath that, you will see WEX and substations, and WEX is wind energy conversion systems, are permitted only in the A1 and A2 zoning districts by special use approval, approved by the county board. Again, I think that's already in your current ordinance. However, what's in addition is where 75% of the site contains soils of having less than a productivity index of 125, the soils should be tested within a quarter-mile radius of where its turbines will be erected. That's out of your comprehensive plan. If you look to UCTC Exhibit 1, I didn't include the whole comprehensive plan because I didn't want to overbear you with more than I already have. Page 26, The review of a special use permit must include an assessment of whether 75% of the proposed site contains soils with a productivity index of less than 125. That's something from the comprehensive plan we think should be incorporated into the ordinance. Definitions are pretty consistent. I don't know that there's any real doubt or there'll be much argument about the definition section. Those are pretty standard throughout most updated WEX ordinances. 153.06, and I don't know if your copy says 5 or A, but it should be A. This is asking for a pre-application meeting held with representatives from the Tazewell County Community Development Department, County Board, County Highway Department, and other departments. The pre-application meeting should be open to the public and notice provided in paper of general circulation throughout the county. Why is this needed? Too often, you will see hearings for a special use application. These are big issues. I don't think anybody can doubt that this is a big issue that has effect throughout. Too often you'll see, as you know, in the state statute, it's a 15 to 30-day notice. It is next to impossible for the public to hire experts to refute the wind energy company testimony in 15 to 30 days. They don't know what the plan's going to look like. They don't know what the sound effects are going to be. They see that when the application's filed, and they won't even get notice sometimes until 15 days. At earliest, they don't always know the application's filed. All it has to be filed is 15 days before with a hearing that goes on. There is no way for someone like me or the public to respond to that, get the necessary experts in that short a time frame. It's just impossible. Now, on the other hand, the wind companies, they've been doing this project for 2, 3, 4, 5 years. They file when they want to. They have their experts lined up. They know exactly what they're going to use, and that's when they file. So you have an unequal time to prepare. You have unequal money. Your citizens, these things can cost hundreds of thousands of dollars to fight. So at the very least, we should give them notice so that they know when the hearing's coming, know when an application's coming, and be able to see what it looks like more than 15 days before. That's the purpose of this. If you look to page 4, subparagraph 5, names, addresses, phone numbers of the applicant's owners. In essence, what we're asking for is an authorization letter. Unfortunately, I've been doing this now for 6 years, 5, 6 years. And I have seen, in fact, Mr. Griffin, who will be presenting later, we had a case early on, at least for me doing this, where there were people who were on the list of supposedly having their special uses, wanting special use, who didn't know they were on the list. So it would be important, I think it's important to make sure that we're not changing someone's zoning without having an authorization letter saying company A, B, and C has the ability to ask for a special use on my property. That's a very common thing throughout the state, especially up north. No way would a county like DuPage County, and I know I'm not comparing apples to apples, but they would not allow you to provide or file an application unless you know for sure that that underlying property owner has approved it. That's all this is asking for. That's not real hard. If you go to page 5, subparagraph D, something else that does not help, it does not stop wind turbines, it's something that's in every modern zoning ordinance, is an application fee. Not even it's not an application fee, it is a deposit. What's the deposit for? It's a $100,000 deposit for the cost that your county is going to have to incur. And if it goes over that, the wind company puts more money in. Why? Court reporters. A lot of counties will bring in outside attorneys. There will be renting of rooms. As you know, we have a room here that's very tight. We have people outside. It may be renting an auditorium or a school. Those are costs that should not be paid by Tazewell County. Those are costs that are part of the wind application and should be paid for by the wind company. And those are costs that in almost all the modern zoning ordinances are required. It's just too big. This is not like a one-night hearing. I've done one that was 36 nights. over an 8-month, 6 to 8 month period. Now, not all of them are like that, but those are heavy costs that you should, as a county, not have to incur. In E, we're also suggesting $100,000 be put into an enforcement fund. So if at any time during the process, after it's, if a special use is granted, there's any enforcement, any investigation that needs to be done, is it a violation of the sound? Is it a violation of whatever? That you're not paying for that. You as a county. This is not something, $100,000 is not a big issue in the grand scheme of how much money they're going to pay to build this. So you need to be protected. Under section 153.07, design requirements, again, very standard for N1, applicable industry standards, ANSI, certificates of design compliance, all very standard things, but things that you should have to protect the county and protect the citizens. Let's go to page 6 at the bottom, setback. And this will be a huge issue. I have no doubt about it. This is going to be the one that Mr. Griffin and Ms. Antonelli fight hard. 3,000 feet or 6 times the height of the WEX tower. And that's the height of the tower is the top blade, is where the blade is at its top. That's how it's defined, and that's how it's defined in about every zoning ordinance I've seen in Illinois except one. And then we asked that it be located no closer to a primary structure than 1.5 times the height of the WEX tower. We're going to get into why this is so important later on in my process, but I will point out a couple things in the meantime. A lot of this ties into noise and sound, but if you look to Exhibit 2, it's a report from Kurt Keelish that he did for DeWitt about 2 years ago, I think 3 years ago. And I know Mr. Maroos is listed here to testify on behalf of the energy companies. He's also an appraiser. If you look at page 74, there's a chart. And Mr. Keelish did a bunch of stuff here. He did a regression analysis. He did a paired sales analysis. And I'm sure when Mr. Maroos testifies, you'll hear more about that. But he looked at this a couple different ways. And at the bottom, near the bottom of page 74, this chart clearly indicates that there's a relationship between distance from a wind turbine and impacts of value that a wind turbine causes. It can be said with confidence that the closer a wind turbine is to residents, the greater negative impact it has on value. If you look at page 176, Mr. Keelish goes on to say the regression analysis extracted a minus 8.5% impact to the overall land value due to the presence of the wind farm. It is projected that agricultural land located within the wind farm zone 0, that was the closer, will experience an overall property loss of minus 8.5% net of the value generated by the wind turbine lease income stream. Property values, you know, and we'll talk more about sound in this, but where I'm from, you buy a house next to a wind tower, or excuse me, a water tower, 80 feet high, 100 feet high, you get $5,000, $10,000 less to buy a lot next to a water tower, 80 to 100 feet high. These things are now 500 feet, 700 feet. I have a hard time believing, I don't care what the experts say, we're gonna hear Mr. Maroos, and he and I have gone through this a number of times in a number of different places, but I have a hard time believing that this thing, as tall as it is not going to affect property. I don't think it's common sense. I think it's just common sense. It defies common sense to say it's going to, that it's not going to. Also, you have in front of you UTC Exhibit 3 and 4. If you look in section 2.7 on the second page, and this is Best's own health and safety instruction, which is a manufacturer of wind turbines. And then again, didn't give you the whole thing because it's very long. If you look under 2.7, if a runway operation should occur, the plant must be, I'm getting old, must be having a hard time reading this. Plant must be evacuated immediately by running upwind, and access to the surrounding area in a radius of at least 500 meters must be thank you, restricted. See, I'm getting really with those cheaters.
I have some, but they.
It probably won't work with the contact that for distance. If you look at UCTC Exhibit 4, if you look at the under thunder section 9.2, and you go to the top of the next page, which is labeled 47, but the third page in your packet, you will see that in a thunderstorm, Nordex, another manufacturer, says, wait in a vehicle at a safe distance from the wind turbine, approximately 1 kilometer until the thunderstorm is passed. Again, they have falling turbine parts, keep a safety distance of 500 meters around the wind turbine. 500 meters is, well, probably 1,600 feet. That's why it's important, not just for homes, but for property, we need to make sure we're protecting property lines. Because if my son, your daughter is out there playing, we need to make sure they're protected. Thunderstorm, 1 kilometer. That's over 3,000 feet. They don't want their own people to be there, but wind companies don't have a problem having everybody live with them. Note that all of these distances in the setbacks, pretty much all of them, have a waiver. That means if I'm Joe Smith, my neighbor's got one, but I'm inside the setback, I can waive that setback as it relates to me. Sometimes those are called good neighbor agreements, sometimes they're called leases, whatever the wind company does, they can pay Joe Smith X dollars a year to waive that. Okay, so what you're really requiring with larger setbacks is the wind company enter into more contracts. You're not saying you can't have wind, but you know what? You have to protect these people. You have to let these people make their own decisions. And if that means there's a monetary value to it, there's a monetary value to it. I was at a text amendment hearing in Livingston County in like 2019, 2018. I think we'll probably see some transcripts from it later, where the Invenergy executive admitted they could build it with larger setbacks. It would just cost them more money. I'll let you go through it. Wax towers, setback distance less than 2 times the height from roadways, 0.5 miles from all large animal shelter buildings, 1.5 miles from any public or private school property line, 1,500 feet from the property line. So we're looking at 2 things, 3,000 feet from a primary structure, 1,500 feet from the property line of a property that has a primary structure. So we're not talking about farms. We're talking about where someone lives or there's got a significant use, not just farming. And then it does allow waivers, et cetera, variances from the county upon written waiver by the state, county, township, et cetera. Height restriction, we're suggesting 500 feet. Many of the ordinances in Illinois have that same height restriction. You may hear that we can't build at 500 feet anymore. Now there's the majority of the turbines that are up in Illinois right now are somewhere in the 450 foot height. They're not in 500. They're not above 500. They are currently, some are going up above 500. If they want and need heights higher, they can come in here and ask for a variation. They have to show special circumstances. They have to show some kind of harm or some kind of extraordinary circumstances, but that's an option available to them. Make them come in and prove why they need more height. Don't just, I was at a county the other day that wanted unlimited height. I'm like, what, are you kidding me? We're going to be at 1,500, 2,000 feet, and we're going to say that's okay, but we don't know where the people are already living. These WEX ordinances or these special uses have to be handled on a case-by-case basis. You also, and I skipped real quick, half mile from large animal shelter buildings. If you'll go to Exhibit 5, this is a report done by the Sutton Aviation Research Center of University of Oklahoma. And it was a study done for prairie grouse of what the effect of those being near wind turbines was. And if you go to the pretty much the conclusion, which looks to be page 1258, which is like 3 pages from the back, right above acknowledgement. It says increased population of wind facilities and associated power transmissions is a potential threat to populations of both species of prairie chickens. And then at the bottom of that paragraph, in the absence of management efforts or cooperation between developers and conservation biologists, we predict prairie chickens and perhaps many other species of open prairie will decline markedly in areas where wind facilities and large power lines are constructed. These declines will be caused by increased habitat fragmentation, which is likely to cause a population decline. There are also studies out there that say wind turbines increase cortisol levels. And with the increase in cortisol levels, things such as geese have not, the growth of those do not increase as fast as those not near wind turbines. Obviously, animal growth is a pretty important part of the rural areas of this county, which is where these will go. That's something that we need to protect and protect the people who work, make their living in these areas. If you go to J, FAA obstruction, marking, and lighting requirements, we're requesting that an aircraft detection lighting system be put in. That's been becoming pretty common. I don't think that's anything the wind companies will probably object to. Since about 2018, that's been approved by the FAA. If you look at Exhibit 6 and 7, it talks about there's some articles and publicity or websites from people, or companies that do these ALDS and saying, you know, we can do these for you. What is it? We've all driven by down 55 near Bloomington, Pontiac, I think is a good place where they're flashing. I remember the first night I saw when I'm driving back from Springfield. Unfortunately, I do too much work down there, and it's late at night, I'm tired, and all I see are these flashing lights, and I'm like, oh my God, what's going on? I thought the UFOs were. Now, that's silly, obviously, but that was my first thought. Then I'm like, oh, this is where the wind turbines are. Obviously, that flashing at night is not something we hope to live with in the county, in the agricultural areas in the country. ALDS, they turn the light on only when a plane is coming. Those have now been approved by the FAA instead of the automatic lights flashing all night. That's just something that's not a big deal, but I think is important for your citizens. Use of public roads. Under L, road agreement includes all affected jurisdictions must be agreed upon. Again, pretty common for every standard updated wind ordinance. All it is if you're going to use our roads, you got to come to an agreement with either the township highway commissioner or the county highway commissioner so that any damage you're doing gets repaired. Again, it's not going to stop a wind energy company from coming in. It's not going to do anything except protect you, protect the citizens from additional costs that you should not incur that are caused by it. Okay, turbine location in N. No turbine or substation shall be moved more than 50 feet in any direction from the location set forth in the special use application. Why is that important? When you go through one of these hearings, there are, as we're going to talk about later, noise limits. Right now, your ordinance is set up on the Illinois Pollution Control Board limit. The wind company or the projects will come as close, it will come very, very close to the level of the Pollution Control Board limits. Okay. 100 feet, 200 feet moving that turbine, which I've been to hearings where someone's like, well, we get to move it wherever we want on the property. But what we found is 100 feet, 200 feet movement will change the decibel level 0.1, 0.2, 0.3, and can often put something over the limits. So if you're going to want to move that more than 50 feet, and there's no reason the wind company can't go do its homework, figure out I can put it here, the soils are good, I can't put it here because the soils are bad. They should be doing that homework. That shouldn't be a risk to the county population because they decided to move it 200, 300 feet. We're suggesting 50 feet any direction. At that level, you're not going to change the decibel level and you're protecting your citizens. If you go to page 9, subparagraph D, zero shadow flicker shall occur beyond the property line of any participating property. I'm not sure if everybody knows what shadow flicker is, so I'll give you a real quick rundown. Shadow flicker is the blades going around and the sunlight coming through the blades to a house, oftentimes a window, and creating a strobe effect. The light would be like dark light, dark light, dark. They don't happen all the time. It depends where the sun is. It depends when the sun's out. It depends the way the blade's coming. However, there is a way to have no shadow flicker. None. They can plan an algorithm to turn it off when it's going to hit that house, when it's going to hit that property. And that's what we're asking to do. And if you look to Exhibit 8, this is technology that has been around since 2011. At least a couple counties I have seen have instituted this zero shadow flicker in recent years. DeKalb has, Christian County has. Those are two that I've worked with that I've seen that be instituted. And what we're talking about is protection of people, nuisance value, nuisance not, and sometimes, I'm not a medical expert, and I know we got Dr. Roberts, Dr. Ellenbogen, Mr. Roberts and Dr. Ellenbogen, I made it back, I apologize. But, you know, there at least is some concept that children with epilepsy, people with certain disabilities may have issues with strobe effect. I'm not an expert, I'm not going to tell you, but at least there is some literature out there to that effect. Okay, now we're going to get to probably the heart of this, sound limits. We're suggesting that no WEX shall be located as to cause any Class A non-participating property receive sound levels that exceeds 38 dBA at the property line of the receiving property, or if the receiving property comprises more than one class of land at the Class A boundary. Right now, you're looking at me going, what the heck is Class A land? I'm sure Mr. Hankard, who is here to testify, will talk about it. If not, he'll be asked about it, I'm sure. Class A land is residential. So if I have I believe, and I think the law supports it, if I have a 3-acre parcel that I use for residential, don't farm it, that entire land is Class A. And as a property owner, I should be able to go to my property line or enjoy every part of my property. My kids should be able to play in the yard. My family should be able to have a picnic and not be over certain levels. And we'll talk about those levels in a second. When I talk about when there's more than one class of land, it's at the Class A property boundary. So there is case law out there, and it's many of the people who, probably most of you who farm, know you live on what we call a farmstead, right? You have maybe a half acre, an acre in the middle, or somewhere in your farm that is your living area. I don't know how big it is, but it can obviously be different size. That is where your Class A land starts, is that area where your homestead. The area outside of that is farmland. There is no classification for farmland, okay? So, but your entire property isn't farmland because you're living on it, and you shouldn't be affected, just like that person who owns 2 acres shouldn't be affected any stronger than the limits of the Illinois Pollution Control Boards and your current ordinance, or what we're suggesting here at 38 dBA. Okay. We have, this will, I'm sure, be a large part of what you hear tonight and whatever following is. There is much literature on this issue, much literature going both ways. And if I was the smartest guy in the world, I'd tell you the absolute answer. But I'm not. And anybody who tells you that they have the absolute answer, they're not telling you the truth. These are projects that we don't absolutely 100% know what happens. We just don't. And I'm not trying to compare the two, but we didn't know what was going on with cigarettes in the 50s. We didn't know. And I'm not saying that these things cause cancer, et cetera, but I'm trying to set an example of an instance where while these things are growing, while they're happening, we don't know the effect, okay? We know there's infrasound, we know there's sound. What that effect is on people sleeping, we'll talk about in a minute. I'm pretty sure it's Dr. Ellenbogen, and I apologize, it's been a long time since I've seen him, who will talk about sleep and how, et cetera. But there are clearly people who are affected by this. There are people who move out of their homes. You don't move out of your home just because you think so, okay? Showing you first. We're pointing your attention first to UCTC Exhibit 9. As you'll see from the PowerPoint, this is a PowerPoint by Dr. Punch that he provided to Christian County on June 23rd of 2020. It was under oath, it was in evidence. Because of the short time frame and location of Dr. Punch, he was not able to be here tonight. He did allow us to use this report, this PowerPoint. But I'll go through it quickly, or as quickly as I can, but I think it's something you may want to read later. He's got 50 years experience as an audiology, that's page 4. Done a lot of writing on this topic, a lot of research on this topic. And if you go to page 8, and the page numbers aren't at the bottom, they're kind of right underneath the heading, kind of a weird place. He said the physical nature of WTN is wind turbine noise. Frequency response, that's when people respond to this, consists of extremely high levels of low frequency energy. Wind turbine noise can often be more intense indoors than outdoors. Because they operate mostly at night, wind turbine noise can be especially bothersome in a closed building. If you go to page 9, wind turbine noise is amplitude modulated over very short periods of time. In that respect, it is different from other industrial noises and transportation noises. Next, it produces intermittent tonal energy that often 10 decibels or more higher than the average values. These high levels of pulsating energy occur at infrasonic rates, typically 1 second or less, making it more disturbing than most other noises. These characteristics result in both auditory and non-auditory sensations. A whooshing sound can usually be heard along with perception of vibration. Perception of vibration. I think when I owned my first car, I had my first car, it wasn't my own. If you roll down a window back in 1978, 1979, the cars were not as built as they are today, where if you rolled it down, you didn't hear that vibration, right? Today, you roll down a car window on a new car, only one window, you hear a vibration, right? It kind of reminds you of that guy who's playing the bass too loud next to you in the car, or whatever, you hear that. It's not an audible sound, but we all feel it. That's what he's talking about. I'm not saying it's at that level, but that's the kind of sensation that people feel. Not everybody, but a significant portion of the population feels if this is close enough. And as he said, this perception of vibration, either of which can disrupt sleep. You're going to hear most likely a lot about annoyance tonight. I am sure right now that my voice is starting to annoy about a half this group, okay? That's not the kind of annoyance we're talking about. It's a scientific measure that says any sound that is proved as irritating or a nuisance, it considers long-term annoyance induced by noise to be a health effect. Many scientific studies, this is page 10, along with the World Health Organization, that's who WHO is, have described wind turbine noise to be annoying to a substantial percentage of the population. This is the kind of common noise that if I'm laying at sleep and I'm affected by this, I'm hearing this every second, trying to sleep. I'm sooner or later going to shut up. In the middle of the night, those things aren't going to shut up. Dr. Punch cites on page 11 to a bunch of studies that link annoyance and low frequency noise. Page 12, industrial wind turbines produce pulsed amplitude modulated tonal sounds that are unpredictable, uncontrollable, and sleep disturbing. And you go to page 14, he shows how noise is much more, this turbine noise is much more annoying than aircraft traffic or rail noise. He then talks on page 15 about a Health Canada study, and we'll talk about that in a little more detail in a minute, where it's almost 14% of people who are exposed to levels between 40 and 46 dBA will experience high annoyance. What's the problem with high annoyance? Biggest one is sleep disturbance.
Your ear things are.
I don't know. Oh.
Children trying to sleep at night. Is the most well-documented symptom of wind turbine noise. And as shown by the National Institute of Health, sleep disturbance on page 18 adversely affects health,
Yeah.
negative effects on memory, reduce the
It's on my hearing aid. I don't know how to get it off my hearing aid here.
Hit the speaker twice.
Are we good? Okay. Lowered immunity disease and negative effects on puberty and fertility. 19 talks about a Cape Bridgewater study in Australia that Stephen Cooper came up with, where the sensations were synchronized with wind turbine operation. You'll hear more about that in a minute as well. The sensations included headaches, pressure in the head, ears or chest, ringing in the ears, heart racing, or a sensation of heaviness. You're going to hear that these are possibly nocebos. I'll let someone else explain nocebos. It's the opposite of placebo, which means I'm hearing something that's not there because I think it's coming. It's probably the safest way to say it. As Dr. Punch says, alternative explanations such as the so-called nocebo effect have been refuted by finding a direct cause-effect relationship between infrasound and health effects. Additional documented reactions to wind turbine noise. I'll let you read those quickly. He suggests a setback distance on page 30 to protect human health recommendations in the literature include minimum distances ranging from 0.5 to 2.5 miles. 0.5 mile for the record is 2,640 feet. Researchers, the distance recommended most often by researchers is 1.25 miles. But some now recommend longer setbacks. We're not suggesting 1.25 miles. We're suggesting slightly over a half mile. Recommended noise levels on that same page 30, recommendations in literature typically limit noise levels to 30 to 40 dBA. Some regulatory agencies and local zoning ordinances support limiting noise levels to 5 to 10 decibels above background noise. How should wind turbine noise be limited on page 31? Maximizing setback limits and minimizing noise. As he says on page 32, infrasound and low frequency noise, which is what you're going to hear, what will be heard, what's a large part of what's heard from these wind turbines, are typically not masked by wind or other noises. The PCB limits, page 37, you'll see in the middle it says, if levels are at allowable limits in all bands, that's the PCB limits. Overall level equates to 51.2 dBA, which we just heard is a level that will affect people and people will notice and have effects. At the bottom, you'll see, and you'll hear more about Dr. Schomer. In fact, you'll actually see the testimony where he says this, but Dr. Punch notes that Dr. Paul Schomer, who was on the panel that recommended noise limits to the IPCB, I think in the 70s, has testified since then that they never intended for these levels that are in your ordinance as the IPCB, related. Your ordinance says these should be, they have to comply with the IPCB noise levels. Those IPCB noise levels were never meant for wind turbines. 1976 or whatever it has, none of us were thinking about wind turbines at 600 feet or 500 feet or 400 feet, especially not 60 of them. So that's why those are really not appropriate in today's age. In the next page, page 38, it says the state regulations that are these octave bands limits that were created 60 years ago, if I were creating them today, I wouldn't use them. You'll actually have, I'll put into evidence the transcript where he says that at McLean County. I'll let you go through the conclusions on pages 41 and 42, but they're consistent with what I've already talked to you about, but that's a good summary of his opinions. Go quickly to Exhibit 10, UCTC Exhibit 10. Again, you'll see on the first page, Dr. Schomer at the bottom. You'll also see Dr. Walker, Dr. Hessler, I think no, Hessler's not a doctor, Robert Rand and Paul Schomer. They've been researching this issue for a number of years. This is from 2012. It's regarding the Shirley Wind Farm in Wisconsin, what many of you may have heard about. It was a major issue. Much enforcement action occurred over it. If you go to page 7 of 13, the third paragraph, the 4 investigating firms are of the opinion that enough evidence and hypothesis have been given hereby to classify LFN, low frequency noise, and infrasound as a serious issue, possibly affecting the future of the industry. It should be addressed beyond the present practice, showing that the wind turbine levels are magnitudes below the threshold of hearing at low frequencies. We're going to hear that these are not able to be heard at low frequency. Because they're low frequency, I can't hear them. But we know we can hear. We know people hear them. Health Canada study talks about it. We talked about this vibration issue. If you go to page 8, at the top, Schomer and Associates, using an entirely different approach, have concluded the design goal of 39 dBA is adequate to minimize impact, at least for an audible noise impact. You see about third paragraph in, it says, based on the above, Hessler recommends. With the Hessler recommendation, long-term average 2-week sample design goal for sound emissions attributable any array of wind turbines exclusive of the background ambient and all non-participating residents shall be 39.5 dBA. So you have 2 major experts saying 39, 39.5. If you look at UCTC Exhibit 11, this we talked about the Cape Bridgewater study a few minutes ago. This is Dr. Schomer's statement after the Cape Bridgewater study came out. It's from 2015. Now, Dr. Schomer, he's no longer practicing. He's not this guy that was hired by a bunch of objectors. He was hired by the wind companies for years. Then he was hired by objectors at times. He's represented both. This is not, you're going to hear from a bunch of people in the wind company tonight or tomorrow night, whatever it is, who represent wind companies. That's what they do. I represent people who don't support wind companies, no doubt about it. But you're going to hear a bunch of testimony from people who only represent wind companies. I mean, they have other business, but they don't represent property owners. That's not what they do. And on the first page, it talks about 3 very simple points. There's at least one non-visual, non-audible pathway for wind turbine emissions to reach and affect people. Talks about the study. If he goes on to say on the second page, it's important, I think your copy may be lightly highlighted in yellow. In the third paragraph, second sentence, the important point here is that something is coming from the wind turbines to affect these people, and that something increases or decreases as the power output of the turbine increases or decreases. The last sentence on that page, and regulators charged with protecting the health and welfare of the citizenry will not be able to say they know of no adverse effects. Rather, if they choose to support the wind farm, they'll be doing so knowing that they may not be protecting this health and safety welfare of all the citizens. You know that is the #1 goal of our elected officials. Let's protect our public. We want services. I know that costs money, but they're all the services we're providing are to protect the public. If we go to Exhibit 12, again, you'll see a study. This one is in 2017, so we're kind of going in date order. Mr. Hessler, Rosenthal, Schomer, Bruce Walker again. You'll see on the first page, and if you go to page 43, which is next to last page, you will see again where the first paragraph under the chart on the left talks about Hessler has a 40 dBA design goal, 40 dBA max limit, Leventhal 40 dBA, Schomer 35 to 39 dBA, and Walker 45 dBA in high ambient areas, but lower ambient locales. Well, that's farm. Higher ambient would be more city than what you have here. The authors have generally found that wind farms designed to a total level of 40 dBA or a bit lower, and participating residential receptors have an acceptable community response. Exhibit 13. This is a study from Falmouth. It's actually not a study, I'm sorry. It's a decision on a Commonwealth of Massachusetts. And I'm not going to bore you going through it, but wind turbines at 40 dBA plus were required to be shut down because they were nuisance. Exhibit 14. This is the testimony from Dr. Schomer in McLean County. He was one of the most renowned wind farm experts in the country. You'll see on page 775, the bottom, what he's talking about. If it's a violation anywhere in the property, it's a violation. Some of the wind companies say that if it's not at the house, you'll see them measure at the home or the middle of the home. I've seen Invenergy try and measure at the middle of the house and say, this is where that limit is. Doesn't matter what the outside of it. If I live on, a house that goes 30, 50 feet, doesn't matter what's on one corner, it's the middle of the house. You need to set limits, and what as Dr. Schomer says on residential property, it's the property line. Again, when we talked earlier, this page 778 is the language that wind farms were never contemplated, should not be considered part of the standard. That's the IPCB standard. And he talks about the 60 years. Do Illinois, on top of page 777, do Illinois rules protect people from wind turbines? Current Illinois regulations? Answer, I don't believe they protect adequately. They're very inadequate. He's talking about the current IPCB regulations. And then he goes on, and I won't read all this stuff, but if you look at page 782, he says, I've been suggesting 38 to 40 dB. He actually means dBA there. I come up with it by applying the American National Standard, which doesn't mention wind turbines at all, but it's worked very well. Then he goes on to page 786. It's clear in your mind that some people's health can be affected by wind turbines. Is that correct? Yes. He goes on to say it's a very small percentage. No doubt. And we'll talk about that percentage in a minute. But if 5% of our population is affected by this, isn't that too much? Who are we going to sell out and say, we don't care about Joe. We care about Jill, but we don't care about Joe because he's one of those 5%. It's not what we're supposed to be doing as a society. That's not what government's supposed to be doing. If you go to page 787, I've been to wind turbines where I personally have interviewed and talked with people, and there are people that I just believe are really bothered in terms of like nausea, which maybe isn't an illness. I don't claim to be a doctor, but what I can say I've seen and heard, there's a small percentage of people that are bothered by wind farms worldwide, but it's not large. That's sworn testimony by Dr. Schomer in 2018. We also have for you UCTC Exhibit 15. It's a report from Dr. Rick James, who's been doing, again, wind farm research for a number of years, and you'll see, I think it's CVs attached at the end. It is. If you go to page 2, setbacks. Based on my experience, the draft language establishing setbacks, and this is related to Ford County, excuse me. Setbacks of 2250 to primary structures will cause a WEX project to violate current IPCB regulations, which require measurement of noise to the property. He then goes on to quote Dr. Schomer about 36 to 38. He's actually quoting the language I just gave you, and says, well, this may appear to be, this is page 3, well, this may appear to be extreme to some. It should be noted that Germany has a limit of 35 dBA LEQ, for wind energy projects in quiet residential areas. That limit has not prevented installation of WEX projects in Germany, which also has a higher population density than Ford County's rural areas, which I would suggest are somewhat similar to Taft. Israel may have a slightly higher population. I know the county's got a higher population. I'm not sure about the rural areas. He says that Harry's experience back of approximately 3,600 feet would be needed to meet this limit in Ford County. That's the 36 to 38. That's why we're suggesting 3,000. We're not suggesting 36. We're not suggesting half mile. We're suggesting 3,000 square feet. Also before you is UCTC Exhibit 16, which is 2020, Dr. Thunder. I'm sorry, I don't know that he's a doctor. Tom Thunder. I don't think he is a doctor, so I apologize. He's an audiologist, been doing this for a number of years. I'll just point you to a couple of the PowerPoint slides. This he did for 2020 would have been, might have been Knox County. In Knox or Christian. Since the adoption of the IPC, this is page 7, since the adoption of the IPCB regulations almost 45 years ago, we've learned a lot about the effects of noise. Certain sounds have an adverse character, and wind turbines have a unique character that consists of a pulsating, fluctuating sound concentrated in low pitches. As you can see at the bottom of page 8, accordingly per ANSI, the 1 hour limit should be 45, if not during the day, minus 6 to 7 dB, or it should be 38 to dBA is what he's recommending. Again, consistent with the 38 that we're recommending from the text amendment. Exhibit 17 is Dr. Thunder's testimony from that same hearing, and this was Christian County. It's that PowerPoint was Christian. I apologize. He says on page 62, wind turbine noise does have a unique character, consists of pulsating, fluctuating sound. And again, he says criterion on page 67, somewhere around 37 to 39 dB. 37 to 39 dB. Health Canada you have in front of you as UCTC exhibit. It's a summary of the Health Canada study. That is the backup for, and that's a part of it. It's a summary of the backup for and cited within some of the information we just discussed. Okay, we're also UCTC exhibit 19. That's Dr. Schomer from Livingston County. I'm gonna have to explain this to you a little bit, and I apologize. There was not a transcript of the text amendment hearing in Livingston County when they instituted 3250 as their setback. Approximately 2017, 2018 is my recollection. Hearing about, it was 17, 18, 19, somewhere in there. He used the Health Canada study to come up with a setback so there will only be an annoyance of a small percentage of the population. Not all, there'd still be some annoyance. And somewhere in that was 3,000 feet to 3,250 feet. As I said, Livingston County, he suggested 3,000. I think the text amendment I proposed was 3,000, and Livingston County decided to go to 3,250. After hearing Dr. Schomer's testimony. And just don't take my word on it. If you see page 29 of his PowerPoint, he's got a chart. And at 3,000 feet, about 2% of the population is annoyed at 40 dBA. Excuse me, that's wrong. It adds up, sorry. At 38%, 30 people, at 38 dBA, 30 people out of 430, the Health Canada study, were annoyed. At 39 dBA, you had another 16, and at the 40, you had another 2. So he took that and tried to get it. I think his levels are about 5 to 6% of the population will still be annoyed at that 38 to 39. Yeah. The you go to page 33 is a nice summary. He says the limit should be around 5 to 6% of those that are highly annoyed. And based on the study done in Health Canada, that data, that should be somewhere between 36 and 39 dBA, would leave you with 5% of the population still highly annoyed. 5%, even at 36 to 39. 5% of your people. We're not suggesting some obscene number that's not going to allow the wind turbines to come in. We're just suggesting that they have the proper setback. Because noise is going to be based on setback for a large extent. But we're asking for two things to make sure that one way or the other, they're protected. Why not just go with the noise? Here's what happens. I'm Joe Smith. I think the noise is too loud. What do I have to do? I call the wind company. They say, we're not too loud. We modeled it, you're fine. Joe Smith is going to have to prove that it's a nuisance. Or he's going to have to prove that the dB is above the IPCD limits. Good luck. Good luck fighting that wind energy company, who today you're going to hear from about 6 experts. Today or tomorrow. That's a huge burden for an individual person. It's a heck of a lot easier to provide this in 2 different ways so that we know we're protecting these people. And for them to try and enforce it on their own is next to impossible. Okay, birds, real quick. UCTC Exhibit 20, you need a bird study. You need to make sure that they get the proper permitting. You will see just recently, about a month or 2 months ago, the Justice Department entered into a settlement agreement with ESI, a wholly owned subsidiary of Next Era Energy Resources, that they failed to get the proper permits for birds and had to pay a fine for bald. They acknowledged that at least 150 bald and golden eagles have died since 2012. Across 50, that's 154 wind energy facilities. 136 of those deaths have been firmly determined to be attributable to the eagle being struck by a wind turbine blade. They had to pay about $8 million to the government. This is a huge issue, one that I'm not saying can't be resolved by the wind companies. In fact, it is on a regular basis, but you should have a study showing that and showing what the effect on our resources are, our animal resources are in this country. And obviously, eagles have a important place in most of our hearts for obvious reasons. Public participation, section 153.11. Again, this goes back to the unequal kind of power. The second sentence says, at least 90 days prior to submission of any WEX application, the applicant shall make a reasonable effort to inform members of the public of the proposed project. As I said, they're doing this for years. The public may only get 15 days. I've had times when the written notice has to be sent out 15 days in advance. I've had clients get it 11 days in advance and have to try and do a hearing in 11 days. It's really an impossibility. So we're just asking to even the playing ground as they go forward. Next is section 153.12, liability insurance. If you go to page 12, we're really recommending insurance limits of $10 million per occurrence and $50 million in the aggregate. Again, that is not going to stop a wind project. Maybe we'll hear that they disagree, but the limits I think you currently have are 1 and 5. I think my limits, my malpractice are bigger than that. Most of my construction clients are like the 25 million. So this is not something that's going to kill a project. The important language, another important language is if you go to line, I don't know, probably line, I shouldn't say what page numbers I'm looking at because yours are slightly different, so I apologize. But if you go to after the 1 million and 10 million and 50 million, you'll see it says with an annual certificate of insurance being provided to the county, obviously something you need because every year, insurance certificates, they become void, they're out of date. And the county should be added as an additional insured with the designation of primary and non-contributory. That is huge. If you don't have that magic language, you're not going to get protection by their insurance policy. It's going to be your policy, their policy, you're going to be in it anyway. This protects the county. Like I said, we're not trying to stop. We're trying to protect the county. We're trying to protect the citizens. This will help protect the county in case there's an incident. That's all we're trying to do here. Decommissioning. I'm not even going to take all 90 minutes. Damn. I probably went through this pretty quick, and I apologize if I went through too quick. But decommissioning. The first line says, at the time, under section 153.13, at the time of the special use application, there should be a decommissioning plan. And the concept of this is the decommissioning plan should be done by an independent engineer, not by the wind energy company's engineer, not by any objector's engineer. It should be done by someone jointly hired that the county approves and is an independent. And it comes out of that $100,000. So it's not your cost, right? So I probably should, I think most of you understand what a decommissioning plan is. When the project's done, you have a bunch of wind turbines that are still sitting here. You may or may not have a company that still has assets. Okay, so understand what happens with these. Company A, I don't think Apex is represented, so I'll use them. No one's representing Apex. Okay, I didn't want to use somebody, but Apex will come in. They won't develop this under Apex. They won't have land leases under Apex. They'll call something, Pleasant Farm Wind Farm, Pleasant whatever. It'll be some nice name, Eagle Ridge. I think you have California Ridge here. They sound nice. They sound beautiful. But they don't have assets. The only assets they have are the land and these turbines. And oftentimes, these are sold. That's part of the business plan, and that's fine, that's their right. But so that company you think you have, which Apex, which has hundreds of millions of dollars, when this thing's done, they're not on the hook to pay to take these wind farms down, these wind turbines down. They're just not, because they're all single-use entities that they use in LLCs to protect themselves, and I understand it, I would too. But that's why they have it. If there's a lawsuit, it's a big lawsuit, and I'm not saying, but, Bill Lukiehans gets hurt, sues, the policy limits are too small, the only thing you can go after is that LLC. Or the county. That's all they can go after at the LLC if California Ridge doesn't take down their wind turbines. That's all you have. Now, they're not leaving that money in the LLC for the 25, 30 years they're doing it. That's for profits. It goes to the maintenance, it either goes to the partners in that LLC, it goes to the holding company, but it's not sitting in that company. So you need a decommissioning plan that actually protects you. Okay, that's why you need it by someone who is not their person, not my person. You need to understand the real numbers. I'm going to show you, or if you could look at Exhibit 21. This is actually a report from Livingston County in 2015. It was an Invenergy wind turbine, or proposed special use. Let me kind of give you the background. Invenergy in that case had an engineer come in, and just so I give you exact numbers. said the decommissioning value was approximately $5,028,000 and change. That's how much it would cost to decommission. And that's based on, here's what a construction cost would be, here's what the scrap value would be. You net them out, and that's how much he said it would cost to do. I don't remember who it was at the time. I had an expert that had it at 18 million. And another one, I think at 14. So the county goes, well, how do we understand this, right? And I'll tell you a story in a minute, because what's now being done and why is, so the county goes, let's hire our own. We got this money, let's use it to hire our own and understand the real numbers. So they hired Patrick Engineering out of Springfield. Patrick Engineering came in, and if you can see on page 6, actually, page 8 shows what the original plan was for the decommissioning expert put out by Invenergy. Page 6 does 8.6 million, so approximately 60% higher. It's the second paragraph of 6.0. That was the net, that's what Dave suggested. Now, how did they get, here's what they do to get there though. If you go back to page 6, they took out the cost of 50% of the access road. What's an access road? That's the road to get to the wind turbine. They have to build gravel roads, they use CA6, CA5, whatever it is, you know, in construction, you know what I'm talking about. Certain size road, they put it in to get to their wind turbines, 1 to construct them and 2 to maintain them. At the end of the day, if you want to refarm that land, they got to take it out. Livingston County, one of the staff said, oh no, just take 50% of it. I guess the thought was not everybody's going to want it out. I don't know. But who knows? If 100% of the people wanted it out, you're $3.2 million low. Because if you go to page 13, the access road excavation and removal on that chart was $3.2 million alone. And that's at 50%. So if you add the other 50%, you're now at, I think, $11.8 million. To the first estimate of 5 and change. That's why it's heavily important for you to protect yourself. Heavily important. Since then, I've done a number of these hearings, and they do it differently. You know, I was able to cross-examine on that hearing because they showed the breakdown. Here's how much we're going to get for our CA5, CA6. And as you'll see in this report, if you go deeper in it, anybody who knows construction, and I happen to represent a fair amount of construction companies, especially road business, you know that once you pull out CA5, CA6, when you buy it, it might be worth $3 a ton or whatever it is, numbers. But when you try and resell it, it's dirty. It's got dirt in it. And you cannot use that on a public project. Standards don't let you use it. So every public project can't be used. And that's where most of the CA6 and CA5 is used. So in that cross-examination, it became obvious that they were adding numbers that really made no sense. Because now, besides the fact that you have to, it has little or no value, you have to haul it somewhere. And as we know, costs are what, $6 a gallon for fuel right now? I don't know where it's down here, maybe it's 5.5, but I think I paid $5.89 yesterday. And that's also why it's important to really understand and make sure you have a buffer in your decommissioning costs, because fuel costs, none of us know what they're, you know, this was done in 2015. God forbid you had to decommission this now. Your haul costs, which are a large part of your decommissioning costs, just don't. Not only your fuel, but obviously labor costs are going up every day right now. Like, you know, we can't keep up. So these are numbers that you really have to protect yourself from. So what's now going on, what you'll see if you don't do something like this, and what we saw in McLean County, Burns and McDonald, what they do and others are now doing is they don't give you the backup. They say, hey, we put this in our algorithm. We have a computer algorithm we put it in. We put in X, X, and X, and it tells us what the number for decommissioning is. Okay, so then you ask, I've asked a number of occasions, how much is that is to haul off CA6? What's your scrap value on CA6? What's your scrap metal on, what's your scrap value on the, I don't know. I don't have that information. It's impossible for you as a board to understand what the necessary decommissioning cost is because they hide it. They send someone who doesn't know the number. So that's why we're asking you to protect yourself. It's from those types of things that you need to protect yourself. It's never going to kill a project. It's just not going to happen, but it will protect your county. I'll go through real quickly some of the highlights of the decommissioning that we're suggesting. If you go subparagraph 4, 153.13A4. Method out, it should include the cost to restore all areas used for construction, operation, and access to the equivalent condition of the land prior to WEX construction. Under 7, the amount of financial security shall of the positive difference between the total cost of decommissioning and restoration work minus the net salvage value, plus a 20% contingency. We're suggesting a 20% contingency for those same kinds of things we just talked about. Fuel costs, labor costs. We're also suggesting that this be, and we'll talk about it in a minute, updated on a regular basis. But if you would have updated this 2 years ago, let's say you had a project and 2 years ago you updated your decommissioning costs, those aren't going to get you anywhere near what you're at today. Construction costs are crazy. I've heard, oh, the scrap metal goes up. There's no proof that this kind of metal is ever scrapped. I've never seen anybody say they've actually seen it for scrap. Maybe they have, but I sure as haven't seen anybody testify that they've ever scrapped this kind of metal. And not only to do that, the haul costs. Where do you have to haul it to? And now we've doubled our haul costs at least because we've gone from $3 a gallon to $6. You'd never be protected. So this 20% may not do it, but at least it's going to get you closer. Again, 7B talks about WEX owner and the county board shall jointly request estimates from construction demolition companies and certify the selected estimate by a professional structural engineer. Those of you who are on the county board, I know, have seen engineering estimates and construction estimates or construction actual numbers. They're rarely the same. Sometimes the engineers are too high because they don't want it to be too high. Sometimes they're too low. But so that's why it's important to get someone who's actually in the business that can tell you what the real cost is. 12 talks about access to the site, provisions triggering decommission, inactive construction for 12 consecutive months if there's a delay in obtaining certification. If no electricity is generated by an individual turbine or the entire project for 12 consecutive months, company dissolves, etc. Those would be decommissioned. Those are from other county ordinances that have been instituted. Under E, a couple pages later, I think it is. Like I said, this draft has a slightly different page number system, so I apologize. Talks about how you should value net salvage, the average of 5 years. You don't want to hit the low and be, in trouble. And that the maximum allowable credit for salvage value should be no more than 50%. And that every 5 years you shall be updating it. If you want to do it more, that's up to you, etc. Okay, 153.17, the last section, so I'm getting really close to done here. A, the fees for processing the building permit application shall be $20 per foot of total height. That is the same as in the current ordinance. We have not suggested a change. That's up to you if you think it should be higher, but we are not, that's really something that's kind of beyond my purview as to what you think. Again, it just reiterates in B, only permitted only in A1 and A2, and by approval of the county board. I want to thank you for your time. I know this is boring as heck, but it is important. I know that listening to me for the last hour and 15 minutes has probably not been the most fun thing in your world. We don't have the ability to hire all these experts that are coming in to tell you, so you're kind of stuck with me. But we've tried to bring you expert testimony from other cases where they've been cross-examined, where these are public reports from well-known experts. And as I said, I don't know all the answers. But I'll tell you what, no one does. So the goal is to protect this. You know, I've said this on, I don't know, numerous occasions, and I don't know if Mr. Roos here or not, but yeah, but, you know, he'll come in and talk about appraisal values. Mr. Keelish will come in sometimes and talk about appraisal values. Who's right? I'm not 100% sure either. Okay? But the last thing we want to see happen to our property values, people living near these things, is drop 5, 10, or 20%. That's a problem. As mostly, you know, my largest asset is my home. I think that's probably the case in many people here that farm their homes. That's their asset. That's what we all work since we're 28, 30 years old to pay off. And to lose that value is really a kick in the shins. So that's the concern. There clearly is something here for health effects. And, you know, don't take it from me, take it from the experts. You're going to hear there's nothing. You're going to hear there's no causal analysis. You're going to hear none of these are peer-reviewed studies. But there are people affected by this. And there are people who need your protection. And thank you most of all for your time. You guys have all been a heck of a lot more patient with me than I would be. And I can tell paid more attention than I have my ADD would probably let me be. But I truly thank you for your time, and not an easy process for anyone. And again, I guess later I'll answer questions. I don't know if it's now or later from the board.
Yeah, typically what we do now is have a time for questions. And so we will open it up to the zoning board first for questions and go from there. Any specific questions from the zoning board?
I have one.
Yes, go ahead.
On this first case that you combined cases with, on section A, it had a moratorium to issue permits to development, placement, construction, operation.
Talk into your microphone.
Sorry. In section A, you have a question about ordinance and moratorium on it. You say a moratorium on development, placement, construction, operation, or modifications. Does that apply to the existing ones that are in the county?
It is not intended to apply to the existing ones. And if you decided to take that out, I think that would be reasonable.
Well, that's kind of what it did.
But yeah, we're talking about new construction, new applications that before you finish this. I mean, I know you had at least one wind farm up that should not stop because of what I suggested.
That was a crucial. Thank you.
I think I stole the language from another county I did that had none. So
Well, that was another question. It might be my mind. We had this one, section 153.09.
yes, sir.
Also the sound one, the second one is 153.09. I don't know where the 153 came from, to tell you the truth.
That's your wind energy is currently 153. So we tried to use the same chapter that you currently have.
Thank you.
And I do think it's important that, you know, we're not, and I guess I don't think that any zoning ordinance amendments you had, so you have California Ridge, and those are under certain IPCB standards. those, because they're pre-existing, would go under your current zoning ordinance at 39, or at your PCB limits. They would not change. Those went under a certain set of standards, and I don't know what position council's going to take, but it is my position that they're grandfathered in under the current regulations. And the change would be different, but it's not like we're saying here, California Reg is at 41 dBA at some house. That's got to shut down these turbines. We're not suggesting that. And if anybody suggests that, that's not at all what I believe the law is or what I suggest. Just to make that clear, which I probably should have done earlier.
Okay, zoning board, more questions? I'm going to have you explain a little more detail on page 6, section H, setbacks. Your 3,000 feet or 6 times the height of the tower. And explain your participating landowner / non-participating landowner waiver setbacks. Explain that paragraph.
Yeah, and I probably should.
For examples.
Yeah, I probably should have been a little more clear here, I guess. Doing this, we've kind of come up, there's a couple different terms that I didn't explain very well. That we kind of just skimmed over because we're so used to it. A participating property owner is someone who has a lease and probably a wind farm on their property, wind turbine on their. So if you're a participating landowner, you obviously can waive the setback because you decided, I'm okay with this being 1,800 feet from my home. Obviously, I'm okay with having it across the property line, right? There's some of the setbacks of property. That's what a participating property owner is. A non-participating property owner is someone who is not part of the special use application. So earlier we talked about authorization letters and special use. Just like anything, Joe Smith says, I'm signed up. You can change the zoning from mine from agricultural to agricultural with a special use for wax. That's a participating property. The guy next door, he's a non-participating property owner if he's not part of the special use application. If he is not signed up or have his property changed to a special use for wax, that's a non-participating property owner. Okay? You got 2 kinds of non-participating property owners. One, I shouldn't say it. One may say, I don't want this thing so close to me, and they're not going to be willing to waive the setback requirement, right, as to their property. But Susie Smith may say, I don't care. I'm willing to have it inside the 3,000 square setback, 3,000 foot setback or the 1,500 foot setback. I'm okay with it. And they can waive the setback as it relates to their property. Now, oftentimes they may be paid something to do that. And that's where we see good neighbor agreements or whatever you want to call them. That's a business deal between the wind company and that person who lives there, that farmer, whoever it may be. That's a business deal that in America, I think we all agree, should be allowed to be had. There is some, there's some setback though that we probably should never allow. And I think, I forget what we did here, 1.5 times the height of the house. So if you have a 500 foot tower, 700, your house should be no greater than should at least be 750 feet away. Why? Just to protect people from themselves, right? We don't want to have blade accidentally fall, a fire, whatever, or someone that close, but the noise level is so big. That's why we have setbacks to start with. This just allows people to waive those setbacks wherever they deem appropriate. Does that make sense?
Okay, but in the example of narrow parcels of property, is it only the adjoining property or it's a total of 3,000 foot? He may need to get 3 neighbors to sign a waiver in order to have a WEX.
Yeah.
So the 3,000 is the benchmark,
Yeah.
not necessarily,
Not adjoining.
not adjoining.
So it would be, because the same person's affected whether you own property next to you. I mean, I'm sorry, I cut you off. I apologize. Do you want me to go on?
Well, and then
I talked to you.
is adjoining, your definition of adjoining 2 parcels together, or a parcel across a road or across an interstate? Or how do you determine that?
I don't think adjoining is used in this ordinance. If it is, I apologize. I don't think it is.
So your 3,000 feet doesn't matter what's in between.
Correct.
It's 3,000 feet.
So you may have an instance where a wind turbine is in the middle of 150 acres, or I don't know, 500 acres, right? There may be no one within 3,000 feet of that. Or you may have one that's 1,000 feet away from a property line, or 1,500 feet away from property line, their own property line. And it may be that there's one neighbor, it may be that there's 2, but the 3,000 feet.
But it's in all directions.
Yes, sir. Just
So
add all the
more than
setbacks.
likely, it will be more than one neighbor.
Yes. Well, here, it depends on how big the parcel is. What you'll find often is that the wind companies will lease properties adjoining already. It's not going to be, I'm going to put one here, I'm not going to have any around it, and then I'm going to put one here. They will try and lease as many adjoining properties as possible so that they have as many options as possible as to where to put the turbines.
Okay,
Can I grab my,
yes.
I'm sorry. I apologize. Thank you.
On the page 7, the FAA, ADLS, did I understand you right that the FAA approved that in 2018?
Mhm. And you'll have a report in there for the FAA that talks about when they had done the testing and proved it. I think it's in 2018.
And so does all aircraft have that technology, that at night when they would fly near that turbine, that it would automatically turn that light on?
I've heard anecdotally that there are some that may not because of its very small size. But this is technology that the FAA has approved for use in wind turbines. And I think, I shouldn't speak for Mr. Griffin and Ms. Antonelli, but I don't think this is going to be a huge point of contention.
Yeah, but our small airport at Beacon, jets don't land there. It's small private planes and,
Yeah, I represent a general aviation airport, so I understand.
okay, zoning board members, other questions?
Mr. Chairman,
Yes.
my question is, going back to setbacks, and you were talking about landowners, so you have a landowner that doesn't reside on the property, but he has somebody living on the property, whether it be a tenant farmer or he's just got the property rented out. What are your thoughts on protection for those folks?
It's a good question. And honestly, one I haven't thought a lot about. The property owner, under the current regulation that we've drafted, could waive, and that person who's renting would be out of luck, for lack of a better word. The one I was thinking of, I can't say it aloud. So that would be the way we drafted it. If you wanted to go stronger, that's obviously up to the board and the ZBA. My guess is that if someone didn't want to be that close and was renting, at some point they're going to be gone, right? Someone's going to have to try and find somebody else. I have seen instances similar to what you're talking about, not with waivers, but where property owners have entered into lease agreements or easement agreements, whatever you want to call them. And the tenant was against it and ended up moving out. But I haven't heard of a waiver instance, but I have heard of instances where, they became part of the easement agreement.
Okay, on page 10, 15310 birds, you call it identified aerial detection system. What's that?
That is, that's an area, honestly, it's beyond me. I know it's something that have been put into other ordinances to identify when birds are coming in, to either slow down the blades, et cetera. And it's something that, I think has been utilized on a regular basis. I'd let the one company probably have a better handle on that than I do, honestly. But I do know a lot of, like DeWitt put that in a couple of years, 3 or 4 years ago. My recollection is the Tradewinds who built that one was able to follow that because they did build a project there. But Mr. Griffin was actually on that case, so he would know much better than I would. I'll let him speak to it.
Okay. Board members, questions? Land use. Yes.
Phil, I've got a question that should be pretty easy for you.
I hope so.
It's basically on discussing the variance between, I'd use that word variance as difference, not as variant, like a zoning variance, of 2219A and 2220A, which is the difference between the moratorium and the new restrictive code. So let's say that a member, a board member or land use member or ZBA member thought that we needed to have some greater protection. I'll use your words, because I can't see too many people that would be opposed to that. And so one strategy says, okay, just institute a moratorium, let's say for a random period like 6 months. I assume that in that, and when you answer this, tell me if you disagree with this, but in that 6 months, we'd be operating under the current language of the Tazewell County zoning ordinance under wind farms.
Yes and no.
Okay, well, hang on. I'm going to finish the question, and I'd like you to answer that if you don't mind.
Yeah, please.
And then, but the other strategy is to say, maybe the ZBA and land use and the county maybe thinks that whether we like or don't like these restrictive additions or changes, that there may be other restrictive changes or additions that we maybe don't know, but we should know. There's a lot of work's gone into this. There's a lot of benchmarking in here, but it's probably not exhaustive. So how would you advise a voting member on whether, on what to do, whether just pass the moratorium on A or go right ahead into 2220A, which is the new code restrictions, sort of without the moratorium? And you can answer that other question too. Thank you, Phil.
Yeah. Let me start with, just so we're coming from the same place. The moratorium, if you institute it, and I don't remember how you asked it, so if I'm not answering your question, because I can do one or two things at a time, never will.
Well, that would, the question was, do we stay with the same language if we pass?
If you pass
Still,
it-
we have it current.
if you pass the moratorium, any current existing wind farm, I think California Ridge is the current one, I think, that would go under the current ordinance. That wouldn't change. Anything, what the moratorium would do is stop Apex, for example, from coming in and filing an application under the old one, so that we're looking at the more updated ordinance, whatever you decide that is, as you go forward. That's what the
We would
moratorium.
stop new M.
That's all it does. And especially when you clean up the language that I screwed up on operation, okay? So that's that. What I would recommend, honestly, it really depends on how comfortable you as a board are. Okay? Do you feel you have enough information? And we feel that after this hearing, we know enough, not this here, but the series of hearings, that we can pass something. Doesn't have to be exactly what I recommend. It can be something, whatever it is, that you feel is comfortable. If you think, hey, we need more research, and that's going to take us longer than till mid-July or longer than the next 6 weeks, then I would suggest passing a moratorium in the meantime. That gives you a 6-month window. If you finish it in 3, you pass the ordinance, the moratorium's up. Does that make sense?
Yes, thank you very much.
Okay, other questions from land use? Okay, I had one other, and I'm trying to find it now. It's in the roads section.
Road is L, it's 7 on mine, but it might be like 6 or 7 on your version.
Yeah, public roads.
No, on page 7.
On page 8, section I, bring all roads used during the project up to at least 80,000 pounds. Well, most of our Haswell County country roads are not 80,000 pounds now. Why the excess in the upgrade?
Well, I think you're going to find that these trucks coming in are more than, or need that 80,000 pounds. These trucks are going to be bringing in very, very large structures. So you're trying to protect, and in the future, they're going to be bringing in, if a turbine, a blade breaks, they're going to have to bring in another one on that road. So so the goal would be to bring these into a way that would protect your roads going forward and not, they wouldn't fall apart because of the heavy use. If you think that, here, I'm not a road expert engineer, if you're a road expert, if the county highway engineer says 80,000 is too much.
Okay, well, Jackie can correct me if I'm wrong. I think our current code says that the roads will be repaired back to their previous quality or better than when construction on the WEC started. And so if it was a gravel and chip road prior to that, it needed to be reinstated to a gravel and chip road versus 80,000. And I'm not an engineer either, but there's road base and everything that is to bring that up to that standard. In a rural county, I'm not sure that makes sense, because then we've got an 80,000 pound road that turns into a gravel and chip road that semi's got to stop, or
Understood.
does that make sense?
It does. And you know what? I think in that case, what it would be important to make sure is that anytime they come back out, because they will be back out, and there's going to be heavy trucks throughout the process, that at some point, maybe every 5 years, they clean up those roads to the current standards. I think that would work. But what you don't want to end up, and I'm not trying to charge them for, that's not fair. I completely agree with you. But what you don't want to see is, at the end of the day, the county or the highway commissioner township, which, as we know, townships have, road commissioners are very strapped. At least they are by me, and I'm sure it's even worse down here because you have more roads. You get more MFT funds, but more roads. That I think you're trying to make sure that this is not a burden on you. However you best think to do that, that's clearly an issue that I would defer to the county and the highway commissioners, et cetera.
Okay. Okay, board members.
As I said before, I don't have all the answers, guys and gals. I'm not going to say I do.
Any other questions? Okay, county board members, would you have any questions for Mr. L? Please go to a microphone.
There you go.
Last year, the board unanimously passed supporting to going against Senate Bill 1602 or something like that. And to maintain local control on wind farms and other facilities like that. I guess, talking to local senators, if we make our stuff too tough, is the state gonna come in and we all follow the state? I guess I wonder how you've been following this and where you stand with that.
I'm probably more familiar with that than about any person. And we're as familiar with that as any person there is. One of the things I do is I am outside counsel for the Illinois Center of Republicans, Illinois Center of Republicans, which may make some of you hate me, some of you may not hate me because of whatever. That's one of the things I do. The other thing I do is, oh shoot, I'm drawing a blank, I'm getting old. The group that fought Senate Bill 1602, I was their advisor on fighting Senate Bill 1602. They hired 2 lobbyists at my recommendation to fight it because exactly what you said, it takes away local zoning control. The setbacks we're talking about are not setbacks that are not instituted elsewhere. DeKalb's a heck of a lot worse. Ford County is worse than what we're talking about here. Christian County is probably, when I say worse, I mean more restrictive, I should say. Christian County, I think, is also more restrictive. And they, with a whole heck of a push, I mean, the wind company spent a ton of money. They hired a number of lobbyists, some of the more powerful lobbyists in the state of Illinois, and couldn't get it done. And that was in a year when we did, quote, energy reform. Whether you consider energy reform or not, I'll leave that to someone else. But that was an omnibus bill of thousands of pages. It was in there originally, and that was going to kill the bill because they couldn't get enough support. That's why it was pulled in those last several weeks. The county ordinances that were passed, county resolutions, and I want to say it was about 80 resolutions that were passed like yours, were a large part of the tipping effect with that not going through. And someone's online watching you going, I can't believe you can't remember the name of the organization. But the concept was not, hey, these zoning ordinances are too strong. That's what the wind companies were saying. No doubt about it. That was their sales pitch. We can't do it here and here and here because it's too strong. Okay. There are a number of counties who have never changed their zoning ordinance. They're still 1,000 feet. There are places to build wind turbines. And I do not believe, I strongly do not believe that any zoning ordinance or any taking away of local zoning authority for wind energy will ever occur, at least for a very long time. And it's not going to occur because you're the tipping. That's not going to be, because there have been counties over the last several years doing that, and it hasn't changed anything. And I don't remember Who's your state senator here?
We've got about 6.
Oh, that's right, we did. I actually know that one of my other jobs is being a redistricting lawyer for the Senate Republicans, but I can never remember where all the lines are. But, down here in particular, at least in the more rural areas, your state senators and state reps are definitely against what was Senate Bill 16. That was a long answer, probably more than you expected. That's what I know about it.
Okay, any other questions from county board? Okay, zoning, this is your last opportunity for questions to the zoning board. Okay, thank you, you're excused.
Thank you very much for your time. I truly
And
appreciate it.
we will take a 10-minute break before we proceed.
Okay, unlock that.
You know what we did? We put tape over the latch to hold it open. We did tell them.
I was gonna give them credit, I'll give it to you guys.
Trying to think of where this should go for the PowerPoint. Right, I'm wondering if it can go up on the podium.
So Dwayne, are you thinking we're gonna get on for 10 or 8? I mean 9.
They have to say what the time is.
Might get a little bit more play.
Midnight was not one of the options.
All right, should we unplug it and see what we get? Jack? Yes. Think we would get more play out of the HDMI cord if we ran it under the desk and over?
That's right. We might be. Not a lot more.
So I know.
I'm waiting for Jack.
Yeah. So then.
We get potential witness. If you see this report.
I can let them sit here and run their PowerPoint. I think that might be best.
Disconnect them out there. Hit one to start.
Okay, if our meeting room could come back to order.
What do you think? Does this have to be under to give them access?
We have two objectors that are going to speak, and first is representatives from EDPR. And so Amy, Katie, and Andrew, is that correct? Okay, I'm gonna have you come up and you name and address, and then I'll swear all three of you in at the same time.
Mr. Chairman, I apologize, I'm not trying to interrupt. I forgot, I don't know what your process is, but I did not ask the UCTC exhibits 1 through 21 with evidence and already in. I just wanted to make that clear that I requested.
You mean this packet?
Yes.
Yes, it is, because she kept a copy for the office.
I just.
Yep.
Thank you.
Okay, Amy, name and address?
Amy Antonioli, 233 South Quacker Drive, Chicago, Illinois. Do I need to keep this up? Chicago, Illinois, 60606.
Okay, Katie?
Katie Chapman, Real Splitter Wind Farm 1. Our operations office is at 201 Northwest Main Street, Oakdale, Illinois.
Andrew Earhart.
Andrew had an operations maintenance event and who will be attending tomorrow.
Okay, then we'll swear that in. Okay, so you two, do you hereby swear or affirm to tell the truth, the whole truth, and nothing but the true self of God?
I do.
Okay, you guys decide which order you want to go in.
And I will start. I'm going to pass out while we're preparing here, so you have a chance to look, a copy of Katie's presentation that she'll pull up on PowerPoint. It's here. One for you too?
We are.
Chairman, we have to speak into the mic, we can't hear either, so.
Yes, yeah, when they start talking, we'll, and they're working on the video out in the hall.
Thank you.
We have enough here in case you need this.
Okay, thank you.
Yes. So we're working on the video issue. If you could just wait a second to begin.
Okay, and I'm not going with the PowerPoint. I can just begin if that's what you're waiting
Well,
on.
we just need them to be able to hear out in the overflow.
It's everything.
We're okay?
Okay.
Okay, she said, and then I realize we're trying to avoid feedback, but talk up toward the microphone so we get the best possible sound.
Okay, I will.
Just a little bit here. We're gonna try.
We don't move it.
I'm not as tall as Phil, actually, so. Good evening. My name is Amy Antonioli with Errant Fox Schiff, and I'm here tonight on behalf of EDP Renewables. EDP owns and operates a rail splitter wind farm right here in Tazewell County. EDP will provide testimony tonight on the proposed amendments on Tazewell County's wind energy ordinance and related specifically to the zoning of wind farms. Developers and counties alike benefit from having a really robust wind development guidelines and ordinance, and we support this group's efforts at updating the wind energy ordinance. We support specific procedures for things like setbacks, requirements to address wildlife and agricultural land, providing economic benefits for the community, as well as provisions to address safety and community concerns because they help the developer and the community alike. We urge the Zoning Board of Appeals, however, to reject the proposed ordinance in its entirety and instead consider the current ordinance or amendments that would bring the Tazewell County's WEX ordinance up to date and in line with other counties. You heard earlier from the United Citizens of Tazewell County that this proposed ordinance was in line with other counties, but it's anything but customary or standard. These provisions, several of the provisions in the ordinance would be in fact prohibitory for the development of wind, and we have some experts here tonight who will talk about that. Many other counties have permitted and will allow the development of successful, responsible, and financially beneficial wind energy projects in their borders. We'd like to work with you to develop an ordinance that's both protective and beneficial for the community. And should the ZBA decide to proceed with these proposed amendments, we would reserve our right to provide more detailed edits and comments at that time. Over the course of tonight and tomorrow, we'll present 2 witnesses who will provide testimony on EDP's extensive experience working in this community. They've also worked in other communities in Illinois, and we'll talk about that. In doing so, we'll highlight the key features of the proposed ordinance that appear to be designed to prohibit wind development. We really don't want developers to walk away from Tazewell County, and we respectfully ask the ZBA to consider our suggestions. EDP's first witness is Katie Chapman, who will discuss a few of the key features I mentioned that would cause EDP to walk away from further development in Tazewell County. And she has a presentation she's prepared for tonight that we will pull up in a minute.
Presentation. Okay, let's do this. Let's go. Screen share. I'm gonna share it.
You guys.
We just have to get it pulled up here.
Well, while we're getting ready, first off, my name is Katie Chapman. I'm a senior project manager for EDP Renewables. I've been with EDP for 12 years now, and I'm very grateful for the opportunity to comment on the proposed ordinance amendment. Tonight, you'll hear from 2 different developers. I think it's important to differentiate that to explain that we are competitors. So we compete with Invenergy on everything from land to power sales contracts. So when you hear us echoing each other, that really is reflective of an industry standard and concurrence among developers. My colleague Andrew Earhart is the operations manager for the Rail Splitter Wind Farm. They had pre-scheduled maintenance tonight, so he'll be joining us tomorrow. Am I good to go?
Did I get scroll through?
If it looks like it's presenting, I can just, it's just not displaying.
Yeah, it's just not displaying.
Can you make this the whole screen?
We do not want to do. Here we go.
Okay. Thanks for your patience with the delay.
Here, here's page down. Here,
Okay.
Scroll. Use
Just
the
scroll. Okay, thank you. I failed IT today. We're the 4th largest operator of wind in the US. We're 6th in Illinois. I think it's really important to note that our projects in Illinois tend to be co-located. So we have Top Crop 1 and 2, we have Twin Groves 1 and 2, we're working on Rail Splitter 2 and Bright Stock 2. That's because we really pride ourselves on our relationships with our communities. And that kind of subsequent development really isn't possible without strong community support. It's a key part of our business plan and it's a key part of our success, and we plan to expand on that moving forward. Oops. Our presence in Tazewell County goes back to 2009 with Rail Splitter 1. We are proud to support 6 jobs here. 4 of our employees work and live in Tazewell County. Over the course of operations, Rail Splitter has brought 6.1 or will bring 6.1 million by the end of this year to the county. About 3 million of that has gone to, can you hear me in back? About 3 million of that has gone to local schools. Over $12 million in landowner payments has seen our landowners through some really tough times, including COVID, recessions, and some difficult planting years. Rail Splitter 2 is also a 100 megawatt wind farm. We are estimating that we could be online sometime in 2025. We are in development, so we do not have a final layout, but tonight I'll share what information I can, and we're definitely willing and able to chat with you, whatever your questions may be. So if you're with the Rail Splitter 1 team, could you give a wave? So the team is over there and we're happy to chat. Rail Splitter 2 is estimated to bring 29 million, of which about 19 million would go to local schools during the first 30 years of its operations. And to date, we've paid landowners over 600,000. On the ordinance amendment, my comments really focus on the items that we view as problematic or as good examples of how some of the ordinance provisions have unintended consequences to stakeholders who we were not aware were involved in the drafting. So we're just respectfully highlighting that, fully aware that the board is very educated in wind given Rail Splitter 1's presence in the county. So if I am redundant to anything, it is not because I am assuming that you are not experts. So with respect to the ordinance, I think it's important to note that if landowners and communities are the heart of our project, the ordinance is really our eyes. It's our go-to for how to site and develop a project in a way that is compatible with the community and is respectful and allows us to successfully operate the project for 30 years. For starters, the 500-foot turbine height limit eliminates current state-of-the-art technology out of the gate. Things like that we view as a clear signal from counties to avoid, because it would be disingenuous to come to a county that is clearly signaling that they do not support current turbine technology, fully intending to use modern turbines, which are significantly taller. I think on this turbine height limit, some unintended consequences might be that a smaller tip height increases the number of turbines, thereby increasing the total footprint of the project. For farm operators, that's problematic because they tend to seek to keep as much land in agriculture as possible. Similarly, the swept area of turbines is greater for a smaller turbine project than fewer taller turbines. It seems a little counterintuitive, but I'm happy to walk you through it. It's pi r squared. Non-participating property line setbacks, we have some visualizations to help you guys understand what this really means when you look at a site. But in a nutshell, Rail Splitter 1 and 2 cannot comply with these, and we would need to abandon efforts on both projects. For soils, apologies, United Citizens of Tazewell County, if I'm not fully or am incorrectly interpreting the ordinance, but our understanding is that the majority of turbine eligible land in Illinois qualifies as prime soils with a productivity index of over 125. The remaining land that falls below that tends to be in areas that are near water bodies. And in our experience, those tend to be the higher value sensitive environmental habitat. Just quickly on decommissioning, I would like to respectfully draw attention to the agricultural impact mitigation agreements. It was passed with heavy input from the Illinois Farm Bureau and includes a number of community and landowner benefits, including provisions for how we deal with drain tile, but going all the way up to requiring developers to provide financial security acceptable to the county prior to construction. And additionally, it gives the county the ability to update these decommissioning plans every 5 years to account for things that were previously mentioned, such as changes in scrap metal value or transportation costs. They are required, so Rail Splitter 2 would definitely be subject to the AMA. On turbine moves under 50 feet, our key points here are that permitting is really the place where community feedback comes to bear. So right now we are working with landowners primarily. We've just started really increasing our footprint and ramping up on really considering turbine locations now that we've signed over 9,200 acres. We can start to visualize where turbines might go. Emphasis on might, the layout that I'll show tonight is definitely subject to change based on comments and feedback from everyone. But turbine moves under 50 feet limit our ability to respond to stakeholder comments during permitting. And that's a really key piece of what we do to make sure that we have subsequent phases of projects. And it also increases regulatory risk because as you move turbines, it appears to us that that would open up the entire project for re-review. And it seems like that would be burdensome on the zoning board in addition to causing a lot of heartache for developers. We really want a secure and stable ordinance and regulatory guidelines before we start investing in a project. We've spent 1.2 million on Rail Splitter 2 to date. And that was after careful consideration of the ordinance and communication with the county and local stakeholders. These two provisions, although they are more minor, are good examples of where the ordinance may have unintended consequences for other stakeholders. For example, providing final Federal Aviation Administration, which is our airspace permits, and road use agreements prior to permit submittal may increase the workload for highway county commissioners because our turbines do tend to move during permitting, which means that the road use agreement may need to be negotiated twice or even significantly updated. We would prefer to see something more along the lines of a conditional approval, but these are good examples of where for fees, smaller developers may be eliminated from participation in development in Tazewell County, and I'm not sure that that was considered. This is our map section. So here we really tried to visualize what these setbacks would look like in the field. This is Rail Splitter 1. The box represents our general project area. And as you can see, the 500-foot tip height setback from non-participating property lines would eliminate all but 3 turbines for our operating project. It's important to note that our substation would also not comply with the ordinance requirements. And it's important to note that our Rail Splitter 2 project would seek to use the Rail Splitter 1 substation to minimize project impact for farmers. For Rail Splitter 2, it's a little bit trickier, but this, even with 9,200 acres signed, is what our project area would look like with just a 500-foot setback. Again, 500 feet is really not realistic for state-of-the-art technology. So if you consider a 600-foot tall turbine, that would require us to sign over 877 parcels. If 16 of those did not participate in the project, it could block all turbine locations currently under consideration. So I think the nutshell version with property line setbacks is that even a modest increase dramatically concentrates decision-making power in the hands of a few. It's up to the community to decide how to approach that and what you all would prefer, but I think it bears noting. Oops. Road setbacks, 12 of our 38 operating turbines would not comply with the current ordinance for Rail Splitter 1. And then for Rail Splitter 2, we've shown our current layout. So this is very preliminary, it's subject to change, but in an effort to be transparent, this is what we're contemplating. I think it's important to note that the 15 turbine locations that are knocked out based on these setbacks, would need to move closer to the centers of fields, which would increase farm operator impact. We were specifically pushed to use larger turbines and to keep the turbines as close to property lines as possible to minimize agricultural impact. And that's pretty typical in farm country. Soil productivity, we weren't sure where prime soils were being taken. So for data, we used the USDA. This map shows the rail splitter 1 and 2 project area in the box, the red box. As you'll note, most of the area is a deep green, meaning that it's not eligible for turbine placement. The area of lighter green on the eastern side is really a watershed. And again, that's where we would tend to see more sensitive environmental habitat. So we deliberately, when siting turbines, avoided that area from the get-go based on previous experience in Illinois. So in conclusion, we consulted internally and externally to find avenues of compromise and ways to successfully proceed with development using the proposed ordinance amendment provisions, and we're unable to do so. So we therefore respectfully urge the zoning board to reject the amendment as proposed. That said, as Amy mentioned, we do strongly support the goals stipulated in the ordinance amendment, particularly because the ordinance is our go-to for how to develop wind respectfully in any county. So we would welcome conversations with anyone, and we would welcome conversations with the zoning board on how we can improve this ordinance given developments in technology since it was first passed. Thank you so much for your time.
Before we wrap it up here for tonight, I wanted to give you a little bit more background about the second handout that we distributed. That was a letter from our noise expert, DNV, and specifically Justin Pugioni. So DNV is a consultant that EDP uses on several projects. And we deferred to a sound expert from Invenergy. Oh, okay, I have one right here for you.
Does the board have copies of that?
I'm not sure if the board got copies.
I think.
Do we have a couple
Yes,
extra?
Yeah.
Okay, okay. So you heard also from United Citizens of Tazewell County, a recommendation, and it be in the proposed ordinance, a sound limit of 38 dBA. What Mr. Lukahans left out is that McLean County, when it was proposed, rejected Dr. Schomer's recommendation of 38 dBA, both when granting EDP its special use permit in 2018, and when that level was suggested for incorporation into the McLean County WEX ordinance. In addition, the Illinois Pollution Control Board noise regulations might have been on the books for decades, but they've been amended several times in more recent years, and the board did not decided at that time not to change the numerical limits, and this suggests they remain protective of human health and the environment. So one of the recommendations we would make is to keep what's currently in the ordinance, which is a inclusion of the Illinois Pollution Control Board limits on noise. Okay, that's all we have tonight. Thank you.
Okay, keep your questions for them to the end. We've got a second one. Is that this packet? Invenergy, and how many people do you have speaking tonight?
We have six people speaking.
Okay, just like them, I'm gonna have to come up one at a time at the beginning here, name and address for the record, and then I'm gonna swear all six of you in at the same time.
Okay.
So come forward. Okay, go ahead.
I'm Jim Griffin, 70 West Madison Street, Chicago, Illinois, 60602. I'm the attorney for Invenergy with the firm of Shane Banks. Thank you.
Thank you.
I am Michael Maroos, Maroos and Company, 1550 Northwest Highway, Suite 401, Park Ridge, Illinois. I am a real estate valuation expert.
Hi, folks. My name is Jeff Ellenbogen from Baltimore, Maryland, and I am a physician here acting as a subject matter expert on various issues, neurology and sleep mostly. My name is Mike Hankard. I'm an acoustical consultant. Business address is 211 East Verona Ave in Verona, Wisconsin.
I'm Mark Roberts. I was asked to come here as a physician to testify about epidemiology. My business address is 525 West Monroe, Chicago, Illinois, and I work for a company called Exponent, EXPONENT.
My name is Sarah Carroll. I'm a project developer for Invenergy. Address is 1 South Wacker, Suite 1800, Chicago, Illinois, 60606.
Hi, everybody. I'm John Acanino. I'm environmental manager at Invenergy. Business address is also 1 South Wacker, Suite 1800, Chicago, Illinois, 60606.
Okay, for all of you, do you hereby swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you guys decide what order you're gonna go in.
Thank you, Mr. Chairman, members of the board. Pleasure to be here in front of you. Again, I represent Invenergy. Invenergy also is developing a project in Tazewell County that's in the early development stages, and Sarah will discuss that more in detail. We do have one PowerPoint presentation, and as we advance the slides, we'll call up the witnesses that are going to be testifying as to those slides. It was important for Invenergy, as you can see, to bring in our in-house and outside experts, because we want to provide this board with factual information in order that you can make the decision here on whether or not to adopt this ordinance. Now, you've heard from Mr. Lucahan state that his clients are not, their goal is not to stop or prohibit any wind energy projects in this county. Now, what the motivation is of the UCTC in filing this amendment in the end is really irrelevant, but I can tell you assuredly what the impact is. And the impact would be to prohibit any future wind energy projects from being developed in the county. There will be no future wind energy projects in this county if this ordinance is enacted. And when Mr. Lucahan's mentioned some other counties that have enacted standards with setbacks that are in the range of what's proposed here, what he didn't tell you is that there have been no projects developed under those such standards because they're simply not feasible, and you cannot develop a project under those standards. Certainly, we understand the county's desire to review its current ordinance to determine whether it should be improved upon and brought up to date, including accounting for new technology that may be available. But we would hope that the goal here of the county in considering this is not to stop all future wind energy projects, because that will be the impact of this ordinance if it is enacted. So let me now introduce Sarah Carroll, and she's going to come up here and go through a PowerPoint presentation as our first witness. Thank you. Sure. We can email that out.
Okay. Hi, everyone. As mentioned, my name is Sarah Carroll. I'm a little closer. Is this good? Yeah. Okay. My name's Sarah Carroll. I'm a project developer for Invenergy, so I have a very similar role as Katie, who just spoke from EDP. Because of that, I just want to reiterate what she said. Us and EDP we are competitors in every sense of the word, every sense of the way. But I echo everything that she just presented, and I know it's been a long evening, so I will try to avoid any repetition where possible. So I am the project developer for Invenergy. We are an Illinois-based energy company headquartered in Chicago. We've been operating now for 20 years. I myself have worked at the company for over 3 years now, specializing developing projects, energy projects across Illinois. In those 3 years, I've had the opportunity to work in counties as close as McLean, Logan, Vermillion, and over from the past year now working with landowners and community members in Tazewell County. I'm here as a representative of Invenergy who does object the current ordinance that is being proposed, because if it were to be approved, then we would no longer be able to develop a project in Tazewell County. Based on the experience that I've had over the past few years successfully developing projects in other counties, I'm here to speak to the proposed requirements in this ordinance that would prohibit us from developing a project here. And again, I'll try to avoid a lot of repetition, just try to give some different context to what Katie has already spoken on, because she hit on all the major requirements in this ordinance that would prohibit us from developing a project. So what's being considered here is a property line setback, we've gone over it, of 3,000 feet or 6 times the height of a turbine. What that effectively means is for the landowners in Invenergy, where we're focusing in Tazewell County, we've signed up 8,000 acres. So that is inclusive of 30 different families, landowners participating in the project. They would have to own a 830 acre parcel just to be able to site one single turbine. The largest parcel in this entire county is 600 acres, and the landowners that I'm working with, the properties that they own, they're closer to the sizes of 40 and 80 acre parcels. To provide a visual here, on the next slide is a map of what the current setback under the current Tazewell County ordinance includes. So if you see this map, the red area is a current setback that is 1.1 times the tip height of a modern day turbine. What that means is anywhere in red, we cannot site a turbine. So those surrounding properties are impacted. Nowhere we can site a turbine. If this ordinance were to be approved and the setback was 6 times the turbine height, this is how that impacts. So what you're seeing there is 1 5-acre white parcel, and that has ended up impacting over 1,000 acres where we cannot site a single turbine and 15 to 20 different participating landowners. To give you an idea, I know a lot of different counties have been mentioned this evening. Here are some counties that have been able to successfully build and host wind projects. The current setbacks are not too far away from what your current ordinance includes. Here outline some other counties that were discussed this evening, including Livingston and Christian. You'll see that these county setbacks are similar, if not less restrictive than what is being proposed today. In any of these counties, once these ordinances have been passed, not a single project has been built. Continuing on to the turbine height, it was mentioned that all modern turbines are higher than 500 feet. That allows us to build projects of the same size, but utilizing fewer turbines and having less of an impact on the ground. Katie covered it really well. So to give you an example of what this practically looks like, Invenergy over in McLean County back in 2019 built the Blooming Grove Wind Project. That project was 250 megawatts, and it took 94 turbines to build that project. The turbine height was 499 feet. Now, just a few years later, we are building the Sapphire Sky Wind Project in McLean County. That's near Bellflower. It's currently under construction. Those turbines are marginally higher. They're 591 feet. But by using those larger turbines, it only required 64 turbines to build a project of the exact same size. So in just a few years, by using slightly higher turbines, we were able to reduce the project and remove 30 turbines from what was used at Blooming Grove. To touch on shadow flicker, what is being proposed this evening, we would not be able to build a project based on these requirements. I think there have been explanations of what shadow flicker is associated with these projects. Like any facility on a property, a home, a tree, there will be a shadow associated with it. As the sun rises and sets, the shadow is going to move throughout the day and it will change. You can imagine that based on the heights of these turbines, it is not going to be possible for there to be no shadow flicker beyond the property line, which just highlights why this is a restrictive requirement being proposed this evening. What Invenergy has adapted, other counties has adapted as a reasonable limit is 30 hours per year of shadow flicker on a residence. So what that means is we will look at any property in our project, any home in our project area, and conduct a model to ensure that not a single home is receiving any more than 30 hours of shadow flicker throughout an entire year. Just to highlight, I think Katie, again, did a good job going over the soil productivity requirement and how that would impact and completely restrict us from siting turbines on the properties that we do have signed up. We have some experts coming in to further discuss the sound limit requirement that is being proposed, which is well over the Illinois standard. The decommissioning requirements that are being proposed are onerous, they're lengthy, and practically they're confusing. So I do reiterate what is being said tonight. It is important that the decommissioning requirements are clear, that is in the ordinance, and I do not believe that is what is being accomplished and what is proposed. And the permitting fees are designed to be higher than those that we have seen in other counties nearby that are successfully seeing wind development come. If any of these requirements and the ordinance in its entirety were to be passed today, Invenergy or no wind company would be able to build a project in Tazewell County. That means that the benefits that come with these projects would not be seen in Tazewell County. We had David Loomis conduct a report. It was an economic impact analysis on our project here in Tazewell. Jim mentioned that this project is still in the early stages, but what we do know is it's going to be a 200 megawatt wind project in southeastern Tazewell County. What those benefits will bring to the community is over a $428 million economic investment into the county. That is dollars invested into this community during development, construction, and operations. A major benefit during the operations of these projects are the property taxes that Invenergy will be responsible to pay. Over the lifetime of the project in Tazewell County, for a project of the size, we're anticipating over $50 million in property tax revenue will be generated in this community. That money, the school districts are the largest to benefit from those. So DMAC and Olympia School District are where our project is located in. I know the Olympia School District falls within Rail Splitter 1 and has already seen those economic impacts from the project. To continue on, if this ordinance were to pass, the landowners, the 8,000 acres that have so far been signed up, they would not be able to participate in this project and they would not receive annual landowner payments, which we anticipate to be roughly $2.8 million annually. The jobs that will come during construction, over 432 jobs, and then we're anticipating 11 permanent jobs during operations. In the report that was handed out to everyone today, this goes into detail on all of these numbers, metrics, but the economic benefits to the community go well beyond these. Every business in this community will benefit from the increased revenue and the increased jobs that will be brought by wind projects. So just as I conclude, I want to again say Invenergy, we just celebrated our 20th anniversary. We're an Illinois-based company and really excited to continue investing in our home state, working in counties like Tazewell. The great benefits that these projects bring and the landowners that I've gotten to work with continue to be my favorite part of these jobs. And just to reiterate, if this ordinance were to be approved, we would have to conclude development of this project and could no longer continue building a wind project in the county. With that being said, we can turn it over. We have some other expert witnesses.
You know, we didn't bring enough copies for all the county board members. I think a few of the copies went to county board members instead of the zoning board members. So
So I think we need 4.
we brought enough for all the zoning board members, but not for all the county board members.
You stated pass up, we've got 4 ZBA members that don't have these 3 exhibits. Pass those forward.
We'll bring extra copies tomorrow for the county board members that don't receive them today.
Yeah, if anybody got there, we're gonna do that.
We're not gonna have.
And let me point out what has been handed out to the zoning board members.
To the right side, sorry.
While Sarah was testifying. First is the report she mentioned by David Loomis concerning the economic impact of a theoretical 200 megawatt project. Professor Loomis could not be here tonight, but he is available and will attend tomorrow. So if you all had any questions about that report, he would be available tomorrow to answer those questions. We also passed out the 2022 policy paper of the Illinois Farm Bureau, which does discuss wind energy. And on page 10, it states the Farm Bureau's position is to support standards for wind energy projects that provide adequate protection of public health and safety, protect private property rights, and allow for reasonable development of commercial wind energy system projects. That's on. We'll get you a copy. So, and that's on page 10 of the 2022 Farm Bureau policy statement. And that's a position that Invenergy is in complete agreement with, that there should be standards that are protective of the public health and safety, but allow for reasonable development of commercial wind energy conversion system projects. The proposed ordinance by the UCTC, however, does not allow for that. And the final exhibit that was passed out to you is a compilation of various counties that were referenced in Sarah's presentation that have reasonable standards that allow for wind energy development. And if the county is looking for guidance as to updating its standards, we suggest you look to those counties that have successfully regulated and seen the development of wind energy projects, because that establishes that those standards do work and do allow for reasonable development. Thank you. We'll turn it over now to our next witness.
Yeah, it's in Jackie's email. I think this was the wrong one. Is it possible to get the PowerPoint in your email that was sent? This might be the wrong one. We can do it out of it.
Yeah, turn off the monitor real quick. You like? Are you still streaming out front?
I'm not doing the screen share.
Sorry. I'm just going to minimize anything that you had up, Melissa.
And I only turned the notify off, so that.
Nobody wants to see all my stuff on my calendar. Looks like in a few. Is it all one?
The first one should, yeah, any of them are the most recent one.
The
I
most
think is
recent one.
probably the best. Yeah, thanks so much. I don't know why.
That's all right.
The right one didn't come up.
No, because I want you to open first. That's not it, correct?
Yeah, that's the old one.
Come on.
Maybe it did open up. I can check if it's that one, right? The second
This
one,
one?
maybe.
This one?
Yeah.
Is there something that you can look at real quick?
Yeah.
That's it.
It's just gonna say sound. This is it. Thank you so much.
Okay, so this is the next presentation.
Yeah,
you're
so
gonna
as long
do?
as it goes on here, everyone else who comes up, we won't have to do this every time. So,
Okay,
all right, that one is right.
then I'm gonna go ahead and I need to do a screen share.
I need to go out and lobby, make sure it's working out there.
It won't until I do the screen share.
What do you need to do?
Thank you.
Did you read what the screen share was? Did you do screen share? Yes.
I do not need any.
Yes, yep, thank you.
I should put your monitor back on. I believe just the arrow there.
Good evening, Mike Hankard here. I'm an acoustical consultant, an engineer who's been working in sound for 30 years. I guess the reason I think you might want to listen to me tonight is I have experience across the country working for not just an Invenergy. I've been hired by counties before to measure noise. I don't really care who the client is. I'm after the level, the facts. And so earlier, I think I was painted as someone who just works for wind companies, but that's not at all true. A couple of things on my CV, so to speak, here is that the American National Standards Institute recently convened a committee to determine how to predict and assess the impact of noise from wind turbines. I was on that committee. The International Electrical Commission is a European-centric group that is currently working on a protocol on how do you measure wind turbine noise. It's tricky. I'm on the United States committee that's reviewing that. So I stand before you here with a great deal of experience, and I'm here only to inform. I'm not advocating for Invenergy or their projects. I'm not advocating for wind. I'm here to give you whatever information you want in the acoustical realm to help make an informed decision. The piano keyboard provides us with a great little analogy here because the Illinois Pollution Control Board regulations are actually a little complicated. They're some of the most in-depth and complicated regulations in the country. So it's not like you're hanging your hat on something that's not well researched or has some teeth to it. This regulation has been around for a long time and it's served this state quite well. So noise is measured on a scale of decibels, just like temperature with Fahrenheit. But then there's this issue of frequency. So you have that's where the piano keyboard comes in. Everybody knows the low notes
and the high notes, and they sound very differently. And I can press those low notes softly and get a lot of low frequency noise, or I can press them lightly and get less. So, and then we humans, we also hear the entire spectrum. So not just that one individual screech, but we hear everything that's in the environment. So the Illinois Pollution Control Board decided to break the keyboard up into 9 groups, and they have a limit for each of those 9 groups. No other state or jurisdiction in the United States really does it in this complex of a manner. So I'm just really trying to get to a little bit of background information for this slide right here. So these are the Illinois limits. So each of those red bars is what's called an octave band. And the Pollution Control Board puts out those limits. So you'll notice they allow more frequency noise in low frequency at the 31, because humans, we're not as sensitive to low frequency sounds. And then as you move up the scale, they have different limits. But I think I can simplify it here. You see, I have an arrow pointing to the limit at 1,000 hertz. Because what happens is with wind turbines, that's the band that matters. Once you meet that band, all the other ones come along for the ride. So we can greatly simplify the Illinois regs by just looking pretty much at that one frequency band. I'm going a little too fast for my own good here. Hang on. So, you know, what residents hear when a wind turbine operates is the sound of the blades passing through the air. Everything that goes on inside what's called the nacelle, the gears and the motors and the pumps, those are kind of secondary. A wind turbine is a fan. It's a big fan. And any fan, I don't care if it's the one in your window at your house or a wind turbine, the faster it goes, the more noise it makes. Pretty simple physics. Now, understand that wind turbines don't keep going faster and faster and faster. They have a limit. It's just a physical limit. They turn at a maximum of about 14 RPM. So as the wind continues to blow harder and harder and harder, they don't get louder and louder. That's a very important thing for everyone to remember. So they put out only a certain amount of noise, and then they don't spin any faster regardless. You'll see numbers. A manufacturer of a wind turbine will put out a document that says, here's how loud our wind turbine is. Much like if you buy a fan at Home Depot for your bathroom, they'll rate them in sound, or your dishwasher, they'll rate them. Well, the turbine manufacturers rate them too. And it's on a completely different scale. And you'll see numbers like 100 or 105 or 103. Those are emission factors. And please don't confuse them with what our residents don't get anywhere near that sort of sound level. So what a resident would hear from a wind turbine, it tends to, I've measured at 17 or 18 different projects, 60 different locations. So I have a pretty darn good data set of what, and these are all residents that are the closest to the turbines, mind you. When we're called in to measure at a wind farm, we're typically concerned with those that are closest, because everyone else is going to be quiet. So when I have gone to these 50, 60 locations, the range of levels that we measure is about 40 to 48. 40 is the loudest I've ever measured. So that's what residents at a typical wind farm in the United States that are closest to the turbines will experience based on my measurements. And our data is being presented next week at the International, or the Institute for Noise Control Engineering Conference. So we are very active in sharing our data with whoever will listen. I just want to draw that distinction between those numbers that you would see from a manufacturer and what a resident would experience. The other important thing to understand is that the Illinois Pollution Control Board limits, like I said, at that one band, the limit is 41. But the rest of the world doesn't work in these numbers. So when the World Health Organization studies wind turbine noise, when Health Canada studies wind turbine noise, and when other agencies study, they use a number called the A-weighted decibel, just to confuse you even more. It's dBA. So when you add all of these bands up, the Illinois Pollution Control Board limits wind turbines to 46 dBA. That's a really important number for everyone to remember. So a project that's cited by Invenergy or EDPR or anyone else, largely speaking, in Illinois is going to be limited to 46 dBA. So that's going to come into play in just a minute. That's the first slide, first bullet on the slide. So Health Canada, you'll hear more from Doctors Roberts and Ellenbogen, but they studied wind turbine noise and they studied up to 46 dBA and found no health concerns. That's not my message, that's their message, but it's important to understand that Illinois limits to the same level that they study. The World Health Organization has long had criteria for noise. They came out with their first document in 1999. They recommended 45 dBA. They came out with another one in 2008. And in 2018, they studied wind turbine noise specifically. It was the first time they did that. They came out with a limit, a recommended limit of 45. So right there in line with what Illinois already does. Now, there's all kinds of different ways to calculate that. And I'm not trying to bury that, but it's very technical. So I'm happy to get into it at another time, or maybe Mr. Lukahans may have a question for me on that. So then let's talk about what do the other states in the United States do. There's a handful of states in this country that have a state law for noise. Illinois is one of them. Colorado's another. Minnesota, New York. 50 is their limit in Colorado. 47 to 50 in Minnesota. 45 in New York. The South Dakota PSC, 45. The state of Wisconsin PSC, 45. So 45 to 50 is the range that states use. I have consulted all across the country at the county and township level. 45 to 55 is the limit that is used by practically every jurisdiction I've worked with. Now, those jurisdictions that have enacted lower limits don't have projects that I've worked on. The US EPA years ago came out with guidance on noise, as has the American National Standards Institute. Their recommendations also fall into the 45 to 55 range. Perhaps you see a pattern, 45 to 50 to 55. 38 is not in that range. So yeah, let's talk about 38 for a minute. Noise is not your normal math. So I've been trying to think of an analogy that can connect with people. And so if you were the county and you were having some safety issues on a roadway that was posted at 45 miles an hour, and you wanted to reduce that perhaps to improve safety. And you thought, okay, what if we brought it down to 38? That sounds pretty reasonable on the surface. Doesn't seem like it would cause any great issues, and perhaps it would help with your safety problem. But noise is logarithmic. So what that's really like in terms of its impact to these wind projects is it's like going down to 20 miles an hour. So now if you think about your 45 mile an hour county highway that has a decent amount of traffic on it and you post that at 20, that's really way off the mark. I think all of us can understand that. So, and that's what you're asking when they ask to go from the 46 that Illinois Pollution Control Board currently limits down to 38. They're like asking you to take that speed limit from 45 to 20. It's a much bigger change. It sounds all nice on the surface, but it's got a lot more to it because of the logarithmic nature of decibels. So where does this 38 come from? I think Mr. Lukahans kind of alluded to the different researchers that have recommended these various things. One of the ways they get there is they say that 45 decibels is it's a 24-hour average that groups like the World Health Organization use. And if you assume that wind turbines operate 24 hours a day, 7 days a week, 365, then the math works out to go from the 45 down to 38. Wind turbines don't operate 24 hours a day, 7 days a week, 365. So that is, it's a complete, they're just doing their math wrong. And it's unfortunate that they bring those numbers to you, in my opinion, in an attempt to obfuscate or confuse the situation. It's unfortunate. The other way, there's the American National Standards Institute has guidelines. And I believe in some of the information that Mr. Lucahan's referenced, it says, they say that the ANSI recommends 38. No, they don't. You can search the document all day long. ANSI makes no such recommendation. They give a guideline on how to come up with your own criteria. And again, it's usually in the 45 to 55 range. The 38 is a complete misrepresentation of what ANSI says. Then there are theories that, I've been working on this wind turbine issue now for more than 10 years. And early on, you didn't have the number of turbines that are operating in this country that we have now. So there were a lot of theories. If you build it, this will happen. This many people will complain. These health effects will happen. We now have we have 70-something thousand turbines in this country. And these theories simply have not come to pass. Things like theorization that 50% of the population will pursue vigorous legal action. That just does not happen. I think you know that from your own experience in this county. And I know that because I'm often the guy that gets called to go do the measurements. And if I got called to 50% of the people in this that live around wind farms, I'd be hiring a lot of people. But that's just not the case. It's a handful of complaints here, sure, absolutely. But it's not 50% of the population. Those theories were never realized. So 38, you look again to the county and local level. I have never been asked to design or help permit a project with a limit lower than 45. I've worked on 75 different projects across the country. I have my second to last bullet is that the sole purpose of this 38 is to stop wind development. That's a bold statement, and it's not one that I like to make. I'm more of a scientist, less of a politician. But I just feel like I need to get that message across that if I was as an engineer, if I was to sit down and they say, hey, make this project work at 38, I would, on the 75 projects that I've worked on, I'd not out of one of them. No. And in fact, we looked at 3 of our Illinois projects. I had one of my staff look at it today. The 38, we said, okay, the receptor that's 38, how far are they from the nearest turbine? One of the projects was an average of 2,500 feet. One of the projects was an average of 3,500 feet. And the third project was an average of 4,700 feet. So they may say they're asking for a 3,000-foot setback, but the 38 actually is a de facto larger setback, depending on the project, depending on the turbine, depending on the density of the homes. So a couple of last comments. It was noted that the Illinois Pollution Control Board was not, regulations were not geared towards wind turbines. That's true, but they were not geared towards any source. They are applied to everything from metal stamping to gravel pits to industrial facilities to air conditioners. They were redone in 2018, and a separate docket was opened just for noise, so that people, Paul Schomer, anyone, any citizen could comment. They held firm. They reaffirmed the limits that they had. So to say, and in 2018 there were 27 wind farms in Illinois. So it wasn't new anymore at that point. Germany was mentioned. Interestingly, I just was there, and one thing about their development is they don't allow for small homes to be developed everywhere. They keep their cities in their cities, and then they have farmland. And interestingly, I think Phil mentioned that the limit there is like 38 or 9. That's true for the city, but they actually allow less protection to the small villages and the rural houses. The limit there is 45. So he had that one wrong. The German limit for homes in the country in the rural areas is 45, not 30. Last thing, he mentioned that Joe Smith, if he had a complaint, at a wind turbine farm that he's going to call and they're going to tell him, go away. And then Joe Smith's going to be responsible to get the study done. That's not true at all. Again, I'm the one that gets called a lot of times. And we've been out to many Joe Smiths where the levels were either high or excuse me, not high, but near for the limit, or maybe they were super low and the company knew darn right well they weren't going to comply, but they sent us there anyway. Because I find industry is fairly professional. They don't just flick Joe Smith off the map. They send someone like us out to document the science. And then if the answer is they comply, then they comply. I've had situations where the answer was they didn't comply, and I delivered that message. And they did something about it. Doesn't happen very often, but it can. So I think the rest of this is just a summary of what I already said, and I think I've said it succinctly enough. So I thank you for your time. And if you have any questions, I'll be here tonight and tomorrow. Thank you.
It's a safety hazard. No, again, my name is Mark Roberts. I'm a physician. My specialty is occupational environmental medicine. And I also have a PhD in epidemiology and biostatistics. And in the last 2.5 years, you've probably heard a lot about epidemiology of viruses and that sort of thing. So I do a lot of different things. If we could go to the first slide. There we go. Let's go to the second one. So my background is, I have a checkered past. I spent 17 years in the state health department in Oklahoma. I finished up my tenure there as the state epidemiologist, doing rabies, scabies, head lice, and everything else. That was back in the days of Superfund sites, and various environmental issues, including Legionnaire's disease. You may remember when that happened in Philadelphia. So we were out chasing down veterans. You may remember swine flu. I drew bloods on pig farmers and pig pens. Quite an experience. But then I went to Wisconsin. I became a professor at the Medical College of Wisconsin, teaching physicians, and we taught 650 physicians around the world about epidemiology. Then I got a wild hair and became a corporate medical director and saw the world from a different light. And for the last 18 years, I've worked for Exponent as a physician consultant to companies, to public health agencies, everything from the National Academy of Science to ATSDR, a number of different areas. I've spent a lot of time doing COVID-19 over the last 2.5 years, helping companies deal with that, starting in Wuhan, China in January of 2020, and till this day. Fielding questions about that. Various infectious diseases, chemical exposures, and energy-related activities, from hydrofracking to wind. I've been dealing with wind since 2013, when I published a paper on the review of health issues and sound. And so that's kind of started where I do some work in wind turbines every year. So it's not a major part of my work, but it's certainly a very important part. It pulls together a lot of my experience in dealing with people who don't like an issue, whether it be a chemical plant, a pulp processing plant, where we have to go in and evaluate the health concerns. I'm using the same techniques in looking at wind turbines that I've used in various other types of plants and various environmental activities. So we can do the next slide. So one of the things first, as a scientist, as an epidemiologist, I'm going to look at what's in the literature. What is it? And you've heard the term peer-reviewed published literature. That's very important to us. And I think in the past 2 years, we've seen what happens when it's not peer-reviewed, when it's not published, when it's not evaluated, when the scientific information is just put out. The internet is full of misinformation of all types. But these are a partial list of, can we get rid of that? Turn it to So this is a partial list that I pulled together of epidemiological studies looking at health concerns around wind turbines. And as you notice, it first started in Sweden, in the Scandinavian countries, and has continued today. So let's go to the next slide. In addition to these peer-reviewed published articles, which they're numerous, a number of governmental agencies, international as well as US-based reviews have been done over the years. A number of them have multiple evaluations, so they don't all have years beside them. Netherlands has been very, very active. France, for example, was in 2017. And so, and the most recent one was Switzerland redid theirs in 2021, and I didn't get that one on there. So it's very important to look at it in terms of it's not just US based. Wind turbines have been used in Europe for a lot longer than in the US. And so there's a lot more experience there. Then you look at the states and what states have reviewed it, public health agencies. I think it's important to call out a couple of things. In the international area, we'd heard about Cape Bridgewater in Australia. That was a study of 6 people who had complained. The complaints didn't match up with when the wind turbines were at full power. There were, I think, 81 sampling periods. 30 of those, there was not data available. So it's an interesting example of what we're gathering information, but it's not a scientific study. And the author, Stephen Cooper, actually has been quoted as saying that it did not determine health effects associated with wind turbines, but it's there. And this is the whole thing, is we have to look at all the information that's coming out, and that's what I've tried to do. We heard a little bit about Shirley Wind Farm, and actually Shirley was one of the areas, one of the wind farms that caught my attention very early on. That was a very unfortunate one in the fact that the Board of Health, the governing body, had asked the medical director for the health department to review the literature. She reviewed the literature, came back and reported to the commission that that was not evidence of a specific health effect, and then she resigned. There's too much pressure, and this is one of the things that you're going to experience, is this pressure both ways, and she is a good example of what happens in those situations. Heard a little bit about Falmouth, if you will, from Massachusetts. That was a strange one for me in the fact I wanted to know why that one happened. First of all, those were turbines that had been stored for a long period of time. They were used to power a water treatment plant or a sewage treatment plant. I can't remember which. But those were not standard operating, as I understand it, wind turbines. And the other thing is the fact that decision was made by a judge. And this is a medical issue, not a legal issue. And so I'm concerned about using Falmouth as an example of health effects associated with wind turbines. The science is just not there. You're going to hear in a minute. Can we have the next slide? There's been human noise exposure studies, actually going into the laboratory and having people in studies where they're exposed to levels of different sound and how do they respond to it. Those are short term, but they also clearly indicate when a person responds to them. But the other thing is a number of them have adjusted. They would go in and have the person, when they came in, they were supportive of wind turbines, and they would listen, and there would be a bias in that direction. They were assessing the bias of preconceived opinions about wind turbines, and then they would give them information to change their opinion. And how did that affect their perception of the sound? Very interesting studies, and it's very important that we continue to pull this information together. And I just saw an article in a pre-published form of a very article that's coming out right now in the scientific literature, again showing that the perception of noise is very, very important in reporting of health concerns. I heard a little bit about annoyance. Annoyance is not a health effect. Annoyance is something that we all have. Different things annoy us at different times. I'll get that right. And so it's very important. It's an indication of a concern, and it has to be addressed that way. It is not a medical condition. I talked about the scientific process, and I think that it's really important. Anytime somebody gives you information, you need to ask where it came from. Everybody has opinions, and it's very, very important to look at the background of where that information came from. There's publications out there that say wind turbines cause health effects, and you look at the authors and you see that they support activities or groups that are against wind turbines. So it's one of the things that we need to look at as an independent individual. Look at the resources, look at the information, where it's coming from, and use the people, both sides of this discussion. Use the people to burrow down to find the nuggets of truth in all this. Next one. There have been two very significant reviews. Robert McConey and his group went in and looked at all the literature in 2014 and sorted through it in a scientifically method. Came to the conclusion that you see there. Knopper also did an independent evaluation about the same time, looked at included a somewhat different set of articles, and again came to the same conclusions. Next slide. So we heard a little bit about shadow flicker, and I think it's very important. Shadow flicker is something that people complain about. I complain about it because I have a ceiling fan that's when the sun comes through the skylight, it causes a flicker. So I've looked at this, and one of the things to consider is that 30 hours per year is a pretty much a rule. It came out of Europe. It's a standard, but that's the maximum. And so we all know that some days are cloudy, some days are rainy, and so not every day, even when the residence is in the position to have shadow flicker, will have shadow flicker, but it's the methods for assessing that. It's always a sunny day. So it's very important to also understand that the flashing of the turbines, when it does occur, is not at a frequency that would cause seizures in a person who has photosensitive epilepsy. And this is substantiated by the epilepsy, never mind, society, and in a number of publications. So I think it's important to understand it is something that's there, and it's something that needs to be addressed, but it is not a health effect. Next slide, please. And this just goes through the frequency. The shadow flicker in wind turbine running at 15 RPM is going to be about 0.75 hertz. And that's well below the level where photosensitive epilepsy would occur. Next slide, please. The other thing is that it was mentioned about placebo and nocebo. That's no joke. That's real. And we know that in medicine, there's a placebo effect. If you think the drug's going to work, it has a greater likelihood of working. If you don't think it's going to work, if you take it, you're going to not think it's going to be as effective. And I think that in our daily lives, we continually have that, not just about wind turbines, but about some people will not drive a Ford pickup. Some people only want Rams. It's decisions that we make based on the information that we have. So it's very important to understand it's not making fun of somebody. It's pointing out human nature, what we like and what we don't like. And if something irritates you, I use the example of a baby crying. Watching the Super Bowl and the baby starts crying. The father is probably going to be irritated because he's got to go up and check the diaper or feed the kid. It's going to be reassuring to the mom. So noises have different meanings to different people. Images have different meanings to different people. So that's really important to consider when you're hearing about these firsthand reports of effects associated with wind turbines. Next slide, please. So one of the other things is common things occur commonly. Headaches occur commonly. Stomach aches, back aches, all sorts of the general complaints that we have are health complaints. It's very important to sort those out. And so one of the things that there's a procedure called an independent medical evaluation where a doctor is chosen to evaluate the patient to see if those symptoms are caused by an exposure or were they pre-existing, for example. We see this a lot in skin conditions and some types of cancer. And so it's very, very important to know, because one of the things that we see, and Dr. Ellenbogen will talk about this from his personal experience, is the fact that people attribute symptoms to wind turbines that may actually be underlying health conditions for another reason. So it's very important to treat those as important to be assessed, but it's not, the literature does not indicate there is a specific health condition associated with wind turbines. So I'll stop there. Dr. Ellenbogen is next. Do I take questions now or do we wait? Okay. Thank you.
You're free.
Okay, great. Thank you. How's it just scroll down? Gotcha. Okay. Well, my father told me never get in between a man or woman after a hard day's work and a warm bed. So here I am, a sleep doctor at the final hour of this meeting. I hope you'll hang in there. I promise to not be long-winded. My goal is really to provide some information and be available to answer questions if there were things that stuck from Mr. Lucahan's presentation that you're worried about or have concerns for. I don't have an opinion whatsoever about whether you should or shouldn't have wind turbines. And I love the fact that that's a local decision for you folks. Invenergy asked me to come today to talk about health-related issues and the potential of health impacts from wind turbines and to answer any questions that might come up. Okay, I can't read that screen, the one behind me, or this one's, I think I'm just gonna wing it, which is fine. The content is, it's really just a cue for talking about it.
It's okay.
Okay, you got it. Anyway, so my training and background, I'm a medical physician, and closest I came to Illinois was studying at University of Michigan, but the rest is ivory tower snobbery. I'm sorry about that. But I do have a fair bit of wind turbine experience. That started a little over 10 years ago. I was asked by the commissioner of the Department of Public Health in Massachusetts, where I was working at the time at Harvard Medical School. And he asked me to join an independent committee of scientists and medical providers to spend an entire year, which we did, deliberating and analyzing existing information about the potential health issues of wind turbines. They were moving towards implementing wind turbines in the Commonwealth of Massachusetts, and they wanted to sort of preload their knowledge. And that was sort of the beginning of my understanding and spending a lot of time looking at the literature of this. We took public comment as well. We reviewed any concerns that people had raised. This is only Massachusetts at the time. And we published a report on that. And since then, I have maintained some intensity and attention to the topic. I've had the opportunity to actually go out to interview, examine, and review medical records of people who have raised concern about health-related issues. And I hope I have some time, either now or in questions, where I can give you an example of the kind of thing that does come up. among the farming community in particular that I have interacted with a fair bit doing independent medical exams, and showing, as Dr. Roberts had pointed out, that there is indeed a lot of misunderstanding about what these things are doing, and in ignoring of the normal medical problems that do happen. And I think what I'll use as a big mouthful, a misattribution, meaning thinking that somehow my vertigo or imbalance has to do with the turbine because I heard that in one of these style meetings, and spending, as one farmer did, a 65-year-old gentleman, imbalance. He spent the better part of 2 years with his legal committee or team, I guess, and suing a wind energy company for causing his problem. I examined him. It was very clear that he had a neuropathy, a problem with the nerves in his legs due to very poorly controlled diabetes. And he spent a lot of time missed on caring for his treatable problem and potentially preventable problem by wasting a lot of time on misinformation. So it's a big deal. Anyway, so I have done that, those so-called IMEs. I'm occasionally asked to review some work on wind turbine related stuff, the Council of Canadian Academies. I reviewed something for the Medical Journal of Sleep, something that actually came out today, which I won't introduce because Mr. Lugans hasn't had a chance to review it, but something that I would like to have the opportunity to share with you about sleep and wind if I have the time. Okay, so I've been a physician for about 20 years. I'm a practicing physician, a practicing neurologist, meaning I do headaches, epilepsy, traumatic brain injury, vertigo, dizziness. So it's a pretty big field. I mostly focus on traumatic brain injury and sleep, but I do the whole gamut of neurology, headache, and the like. Okay, now in wind, the input is that we're focusing on today, and I'm getting long-winded, so I'm going to start moving a little faster. The input is sound or flicker. Those are the two big inputs that we're talking about for potential health effects. And the potential health outcomes are sleep disruption, cardiovascular disease, headache, nausea, imbalance, seizures, as you heard tonight. And if you Google this topic, you will see a near endless list. Okay, now, I understand Mr. Lugans when he was fairly dismissive of the concept of peer review, but I want to reintroduce it. I know he is not dismissive of the concept generally of quality work, and I think that's really what we're trying to get after. And I think that there is very little and very poor quality work on this topic, and if you were to look at some of the fairly far-fetched claims that are about impact of wind turbines on health, you'll find that coincidentally, they also are very poor quality work. There is one very definite exception, which is a study done by the government of Canada, casually called Health Canada. It is the largest, most rigorous study done. And I say study, but it's really studies. They have published now double digits. I think it's 10 peer-reviewed publications, and it has been fairly heavily vetted. Let me just spend a minute so that you have this in your head as what a good quality study is all about. They studied over 1,200 people in Canada living near existing spinning wind turbines and said, is somebody that's closer to the turbine, that's exposed to more noise, are they more apt to have any number of a set of medical problems? And on the right, you see sleep, stress, hypertension, headaches. They were fairly exhaustive in their hunt. Some of them were on reports, subjective reports, not the best way to be confident, but some of these were also physiologic measurements of blood pressure, of hair cortisol levels, of sleep physiology. So it's a really intense, very rigorous, very well vetted study. I'm almost out of battery. Awesome. Okay, so they measured the existing turbines in existing wind farms, and so they only had noise that went up to 46 dBA, which is a pretty important number here because of what Mr. Hankard had reported, that that is consistent with your IPCB, if I pronounce it, the Illinois Pollution Control Board. So 46 was what they were comparing, and they were looking at how health fared among those people compared to people exposed to low or no wind turbine noise whatsoever. And of all of the health measures that they looked at, all of them, not one popped up as having a wind turbine related issue, not one. With exception of annoyance. Now I, as a medical doctor, I don't consider annoyance a medical problem. I consider it a real problem. I get annoyed by stuff too, and I hate that. But I don't think of it, you won't find it in a medical textbook, you won't find it as a billing code, you won't see a specialty that works on annoyance. And to the extent that we feel that annoyance leads to the problems like cortisol levels and blood pressure and sleep loss and so forth, why wouldn't that show up also in the Health Canada, which was measuring those very things among people living here? Maybe the more important message, and the last one I'll just say on this, Health Canada, I'm getting close to being done, is that, when you look under the hood at what is annoyance to Health Canada, that did have a significant percentage of the population that were annoyed, what you'll find is that only a small fraction of that annoyance was due to noise, that the bulk of it was due to other things. People didn't like the sight of them. And more importantly for this conversation, they didn't like the concerns that they had for public safety, for their personal safety. Where did they get this concern for personal safety, meaning their health? They got it from hearing things other than from speculation. Now, Mr. Lukahans, I have not met personally, and he seems like a very nice guy and a very smart person and very articulate. He has the luxury of raising his hands and saying, I don't know. I don't have that luxury. I have to focus on data that exists and report on the best quality that I can. And when I hear sleep and cortisol and blood pressure problems and seizures and fairly significant medical issues that would scare the you know what out of me, I would get annoyed to know that there was a wind turbine in my neighborhood too. And I would have concern for personal safety as a result. Mr. Lukahans is relying on two people as his experts. One is Mr. Thunder, who he, I think just by accident called an audiologist. He's not, he's an acoustician, he's an engineer, and as far as I can tell, a very smart one. And that's great, I love engineers. But to my knowledge, he has not had a single course in human physiology or disease. Dr. Punch, on the other hand, is an audiologist. And just so that we're clear on what an audiologist is not a medical doctor. An audiologist is a doctor of hearing. So if you had noise-induced hearing loss, if you needed a hearing aid, that is their specialty, full stop. So these are the people that he's relying on for the experts of cancer and sleep and cortisol and seizures and blood pressure. They're no more expert on those topics than anyone in this room. Mr. Lukahans has never called me to discuss these issues. I would talk with him freely, and he has never said to me, hey Jeff, what's this seizure thing all about? Had he, I would have said the following, and this is just going to be an example. I don't want to drag on and on, but I think this is a good example of what I would have said to him, something like what I would say to him about many of the other things he's raised. Epilepsy, from flashes of light you may have heard of, it's called photosensitive epilepsy, PSE. And the Epilepsy Foundation has a really nice website on it. It's really clear. It's very rare. It's only about 3% of people that have epilepsy at all. So epilepsy is a very small part of the population, a disorder of seizures. And people that have this seizures as a result of flashing lights, those people are rare among them. It's usually in childhood, it's treatable, and people have growth. But you don't need to remember anything. The only thing that you need to remember is a wind turbine from shadow flicker has never and will never cause a seizure. Why is that? Because these turbines spin at less than 1 hertz, meaning the flash of light that you physically experience from the 3 blade at full speed is less than 1 hertz, meaning less than 1 flash per second. We know that photo responsive seizures occur at about 5 hertz, maximally at about 10, 15, 20, up to about 30, and then past that it's too high. So in other words, let's say it was 1 hertz frequency, to keep the math simple, for flickers of light that turbines actually produce. And what it takes to produce a seizure is 5 times, 10 times, 30 times that speed of flash. So that would be like saying, well, you know, it's unsafe to drive a car. And you say, well, what, I'm going 65 miles an hour. No, at 325 miles an hour, 5 times that speed, it's unsafe. Well, sure, 5 times, 10 times the flashing of light, sure, that's a problem. That's not relevant here. And I don't think that we need to rely on an acoustician and an audiologist to tell you that. And I think the Epilepsy Foundation has information that I can provide and answer more questions. But this, to me, has become a little bit of a topic of passion because of the annoyance and the concern for public safety, and the fact that I think that hearing things like blood pressure, seizures, hypertension, sleep loss, and so forth makes people uncomfortable, makes them an annoying structure. And so let me just close with that. And I would simply say that, as I said from the beginning, I don't really, if you have turbines or don't, I wish you great luck with your community. I don't have an opinion about that. If you're not having wind turbines because you feel there is a health issue with the Illinois Pollution Control Board backing you up, I do have an opinion about that. I would say that would be a false choice. I think that the IPCB is that protective thing for public safety and is a reasonable limit that you can reassure yourself that you'll have public safety and health. Thank you.
Okay, we are approaching the limit of our attention span. And so for the testimony that we've heard tonight, I want a chance for the board to ask questions and not bring them back tomorrow night, you know. And then they will ask more questions tomorrow night as you finish your presentation. Okay?
Can I ask a question? Can I ask a little more how long the objector's testimony is going on? I got 84 minutes or something like that already.
I didn't look recently. Right. But there were 2 objectors.
But if say all objectors 90 minutes, if I'm not mistaken, sir. I'm sorry, I didn't hear that.
They said they were going over the 90 minutes.
Hold on. Yeah.
So I think we were of the understanding that they were going to come together and do a presentation together, which would have been a full 90 minutes joined.
Yes.
And that was not the case. They chose not to overlap testimony, but they're still going to try and stay as close as they can to the 90 minutes. Rather than 2 fully separate.
That's the board ruling. I just want to make sure, because that's not how I understood it. So I apologize for interrupting, but that's just not what we understood. And we'll go with what the board wants to do.
Okay, zoning board members, questions for the testimony that we've heard tonight?
I have several questions for Ms. Chapman.
Microphones here. And those 2 seats here. And those 2 seats here to the side.
Do you prefer me to stand or sit, and maybe we could get going while we're situated?
That's fine. So when you were discussing your ordinance amendments, you said that you were going for the 500-foot turbine height limit would cause more turbines to be built, I guess. What is the height that you're proposing to the tip of the blade?
Okay, so let's back up a little bit. Current turbine technology, the trend is to build bigger, stronger blades on taller towers. So that achieves two things. One, you get to a better wind resource by going taller, but two, a larger machine can have a larger energy output, so you can achieve the same nameplate capacity, it's called, but the same energy production with fewer machines. So that's part one. Part two is for the 500-foot tip height limit. That limits you to about a 2 megawatt machine. And so I think what you're getting at is kind of the difference between a larger turbine project and a smaller one. Is that accurate?
Yes. I'm just looking for the overall height of what you're proposing to put in on your rail splitter 2.
Okay, so rail splitter 2 is estimated to be a 2025 project. Right now, we're waiting on interconnection studies, and we don't know when MISO is going to produce those, so we're kind of on hold for that. And in the meantime, we're doing stakeholder outreach and leasing landowners. Long way to say, we will choose the turbine that is most suitable for the site based on what is in the ordinance, what our landowners prefer, and what is available on the market. So those three things inform turbine selection. Short answer to your question is 650 feet tall is not out of question. My guess, total guess, is that it would be closer to 600 feet. Our landowners would strongly prefer 3 megawatts and up to minimize agricultural impacts, which puts you well above 550 feet. And that's with a custom tower.
Okay, thank you. The next one was, there was discussion about if a turbine moves more than 50 feet, requires entire project to undergo re-permitting. How do you select a site? How do you go about selecting a site? I think it's more than just taking a look at a map and go, yeah, we're going to put one there.
Yeah, very much so. And if you look at the layout, the turbine numbers don't make sense because we've already dropped some based on community feedback. And we'll continue to adjust as we go through. In general, when you come to a site, and for Rail Splitter, we did this, you come, you speak to stakeholders, you take that input, and you give it your best for all. So here, we thought solar would be most appropriate, but based on landowner feedback, they gave us a very clear no. Actually, we would prefer to see wind for the agricultural impacts that we just said. So we pivoted, and we're pursuing wind now. So kind of step one is talk to your landowners, talk to your stakeholders. Step two is go out and actually understand the ordinance, understand specific landowner requests. So here we spoke with the county, we spoke with 2 different landowner consortiums to negotiate a lease that was appropriate for everyone so that we can move forward with a standard lease and treat everyone fairly. And now we're working on signing neighbor agreements and kind of extending that footprint. Right now, the 9,200 acres that I mentioned is about 80% of the land that you would need to develop a project in the current ordinance. So we're really working to fine tune that. So for example, for neighbor agreements, you really want to get everybody within about half a mile to a mile of turbine so that they have an opportunity to get revenue from the project for its life cycle, even though they don't have project land that is needed. Does that help?
Yeah, that does help. My part of the question, I guess, would be, do you do a scientific study of prevailing wind currents and those type of things? Certainly, you're not going to put one down in the valley. I would think you try to get up on ridge lines and those type of things, correct?
Absolutely, and that's another reason to avoid areas with water bodies because those tend to be your lower lying areas.
Okay.
We have a meteorological tower up now. We'll be collecting wind through construction. We'll have probably 1 or maybe 2 more Met towers. Meteorological towers are called Met towers for short, up to help us identify the best wind resource sites. We'll also do environmental studies, detailed soil studies. There's quite a list if you'd like to hear.
Okay. And then one last question. I think I heard somebody say that the maximum RPM is like 14 RPMs for. So on a tower that's 600 feet tall or top of the blade is 600 feet, if it's moving at 14 RPMs, what's the tip speed?
It's slower than the speed of sound. So we, as turbines get bigger, you need to slow that RPM down. And that's part of where the efficiency of the larger turbines is coming from, is that they're actually utilizing lift rather than speed to kick off electrons. Thank you.
Zoning board, other questions? Okay, I had a couple and I don't remember which person talked about this. if I understood right, it was this particular company's policy to limit 30 hours per year shadow flicker?
Yes.
And then we saw some medical studies that indicated 30 hours was an acceptable level, et cetera, so on and so forth. Is that where you got your standards?
Exactly. That's what our standards are based on. And when I was referencing that, so counties in Illinois, that is a standard that they've seen them adapt. The Sapphire Sky Wind project that we're building in McLean County currently, that county does not have a shadow flicker requirement or a limit. And so when I mentioned that metric of 30 hours per year shadow flicker, that was something that Invenergy, our company, chose to apply to that specific project.
Okay, and so should, and I thought in one presentation too, it said on a sunny day, it was approximately 30 minutes per day. Okay, and there's some days that are cloudy, which provide little or no shadow flicker. But for those people in the footprint that receive shadow flicker, do you have any other plans to mitigate that even farther, like drapes, curtains, blinds provided by the company to those people?
So nothing along those lines. I will start off by saying we, Invenergy, we are going to want to talk to every single person within our project area. If anyone is interested in signing up for the project as a whole or something, I think Mr. Lucahan's reference is a good neighbor agreement. So if they have maybe a smaller property with a home on it, they don't want to sign up for the project, they don't think that a turbine will be placed on it, we'll actually sign a good neighbor agreement with them. So they're actually still receiving a payment, but there are no facilities located on their property. The intention of that is that we want to continue being good neighbors. We understand they're going to be living with the project. And so that would be a type of payment I think maybe you would be alluding
They
to.
could use to buy their own drapes to close for that 30 minutes.
Sure. We would not be providing drapes ourselves.
Okay. Zoning board, other questions? Okay, I had another question, and this was for one of the doctors, and you talked about the flicker and affecting epilepsy and so on and so forth. People that have autism, is there any studies on how it may affect them?
To my knowledge, there's not a single study looking at autism and wind.
Okay. And do you know of any instances where that may trigger a reaction in a person that has autism?
That has never been reported to me. I'm not a pediatric doctor, so it's quite possible that someone wouldn't report that to me. Being open about that, I would speculate just as likely as not that a child with autism may specifically like wind turbines. So I don't know.
Yes,
but there's no study. But I do.
But there are certain things that set them off.
Absolutely. And I'm not saying that there's never been a problem that has not been reported to me, but I can say that it's not been a study issue.
Okay. Land use questions? Yes.
Sarah, this is for you. At least this was in reference to a comment you made. I don't necessarily mean it's for you. But you were talking in your presentation about some of the concerns that you had or that you guys have experienced in regards to the area of economic development. And I wrote down this, tried to catch it as a quote. you said after adopting the additional restrictions, like, for example, are before us, not a single wind farm project has begun. You stand by that? Did I capture that correctly?
If I said a single wind project could not be built with these restrictions, nor has a wind project in the state of Illinois that exists.
Okay, all right. So we got a question. I know thousands of county board members. You across the country, but especially in Illinois. And there's not too many fools, especially if they've been doing it a while. And so I think they would want to balance the protection and the prevention on the part of their citizens with economic development and wind farm development. You mentioned, I saw on your slide, 428 million in just Caswell County in economic investment. That's impressive. That's really good for our county. It's really good for our citizens. It's really good for everybody. So my question is, why would these county board members in all these counties adopt all these regulations that just shut down 428, for example, in our county, $1 million worth of economic development and investment? I have an absolute, really hard time understanding that. So if you could explain that to me, I'd appreciate it. Thanks, sir.
Unfortunately, I cannot speak to the decisions that were made at the county. The only thing that I would like to highlight is the slide that was in my presentation. We'll have more copies of that tomorrow and can send it out to the group, highlighting some of those ordinances that were passed in counties such as Livingston and Christian County recently. I cannot speak to why that decision was made, but I can just again emphasize that after it was made, not a single project has been able to be built, and they will not see the investments from that.
And if I could add to that, and I work all over the state for multiple, project developments, not just for Invenergy. And I can tell you it's rare for counties to enact these types of standards that would prohibit any wind energy development. It's rare, but what we're talking about is a proposed ordinance that will do that. So we're highlighting some of those examples, those few examples of counties that have adopted the standards and thereafter have not seen any wind energy development. Now, why those counties do that, I have to give you the same answer Sarah did. You'd have to ask those county board members that you know, but it's relatively rare in Illinois for these types of standards to be enacted as are being proposed here.
Hey, land use questions? County board? Okay, we're going to confer here a minute and give our instructions for tomorrow night's meeting. When we reconvene tomorrow night, we're going to pick back up here and you're going to finish quickly.
We will.
And just like tonight, the zoning, the land use and the county board will be able to ask questions. Then the petitioner has the right to ask questions of you, and you have right to ask questions of petitioner. And then we're going to start on comments from the public. And currently we have approximately 14, 15 people signed in, and we will take them in order as we receive the request. Okay? Question? If we're in session. If we conclude tomorrow night, we will not have the next session. We don't know how long this is going to take.
Okay. I just had personal impact story to tell about.
Okay, well, that's not at this time. And, okay. That's, we will adjourn until 5:30 tomorrow evening. Recess, not adjourn.
Thank you, sir.